May it please your lordship.
Yes.
My lord, I beg to mention item number 18 and 19, lordship. Lordship, in this matter, lordship asked me to serve the copies by Dosti service as well as normal registered post. As per office note says the lordship service notice served lordship, but the await service report. My respective submission, lordship, I have served the copy to the standing council of the AICTE and as well as UGC.
No,
So-
we will call the matter.
Lordship.
What is your prayer today?
Today I pray, lordship, this matter maybe I pray lordship, next week any days by showing the name of standing council AICT as well as the UGC, lordship. Because
We'll call
it's-
the matter.
I pray, lordship, I have other matter, lordship, so kindly accommodate me, lordship, at 2 or subject to convenience anytime.
When do we list it?
Lordship,
When do you want?
lordship, next week, lordship, in the meantime, service will be, because
Okay,
their
okay.
name may be shown, lordship,
Okay.
only.
On
Only
the prayer
limited
being
time.
made by Mr. K. Majumdar, learned counsel for the petitioner. These two matters then adjourned to be listed in the next week.
By showing the name of standing council AICT,
We have to see it. Without going to the record, we cannot.
lordship.
Wait, please, my lord. Wait, please, my lord.
Yes, yes.
Prayer seeking acknowledgement to item 16, my lord, on behalf of Mr. A.M. Bolwar. The conducting council is out of session.
Item number 16.
16, my lord. Just come up for the first step.
Okay. Mr. Sharma, learned counsel appearing on behalf of Mr. A.M. Barua. Learned counsel for the appellant. The matter is then adjourned to be listed after 1 week.
Yes, my date may kindly be fixed if it pleases my
Why should we fix the date?
my lord.
This is listed for the first time today.
Yes, my lord.
Okay.
Yes,
After 1 week, in the next week,
Yes.
on a date to be fixed by the registry. Yes.
My lord, one pending matter, my MSc appeal, my lord. Insurance company filed this case, that case only 1 lakh already given, my lord, that case. It
When
was
do you
last
want?
listed, my lord, on 28/8/24.
When do you want?
My lord, let it come on 19, my lord, or 16.
Under which column? Hearing? Here.
No, order.
Okay. 19.
Listing of the interlocutory application for correction of the order by the. Because last week, and we lost it. Fixed it. After a week, that's why we have corrected the order. Friday.
Friday?
Correction of the order.
Friday, okay. Yes.
Lordship, item number 31, as instruction from my client, I am praying for withdrawal of this case. Both parties are settled. Lordship.
Item number 31.
31,
Okay. Mr. Your name, please.
and Jamal.
And Jamal, learned counsel for the petitioner, submits that he has the instruction to withdraw this petition accordingly. CRPIO number so and so stands dispose of on withdrawal. Liberty? Not necessary.
May I please, lordships. One hearing matter, my lord, on last time for the, my lord, appellant, my lord, respondent, my lord, the claimant, last listed in the year of 2022, my lord. And thereafter matter has not been listed. I would like to pray before this lordship, so list the
In
matter
the
on,
hearing column.
my lord,
When?
on my lord, on 24th, my lord, if 24th, if of February,
March.
March,
First week of March.
obliged, my lord,
Yeah.
March obliged.
It's an old matter.
When do you want?
On 24th March or 18th March. And it's under hearing? Yes, it's under hearing. Can it be listed on 24th March? That March already there. 26th March. 26th. Can it be 24th? Okay, good. Okay,
Yes.
Lordship, I beg to mention for listing up to MSc appeal for hearing, March.
March.
Date?
May I please,
10th.
may I please, your lordship. Lordship, I beg for listing a CRP, lordship. It was filed, lordship, 27/1, lordship. Lordship, can it be on 16, lordship? Because next date is fixed, lordship, on 19th of February, lordship.
16.
Lordship,
On 16.
16, lordship.
Okay.
Obliged, lordship.
Maple, with concern of other field lordship, I beg to mention item number 3 lordship.
Item number
3. Matter may be adjourned lordship. Next, any date.
It's taking time. It's service already committed.
Next, any date, Lordship. Except
No,
today.
if it becomes infructuous, then what purpose will be served by adjourning the matter to another date?
Moreover, the self is also not maintainable there because the order is filed, order is filed under application under section 9900 and this order is slightly decreasable, that appeal will lie. They have filed civil petition.
Next, any date, Lordship. My senior is come.
Okay.
Friday.
Okay. As agreed by learned advocates of both the parties, recessal lays the matter on 18th. Okay.
Please.
May I please, Your Worship? I beg to mention for listing, this item already reached on 25/11/2025. Due to lack of sufficient time, this
When do you
matter
want?
is arised. Huh?
When do you want?
14,
14. Under which column?
Huh?
Under which column? Hearing column, admission
hearing,
column?
hearing.
Hearing.
Voting is set in the month of March, and March. And March.
Yes.
Obliged.
I'm playing for listing of an IA of delay confirmation on 30th, Your Lordship. Under orders column.
Oh,
Item for motion, item number 1 and 2, Parliament meeting.
yes.
So the affidavit which I was required to file here.
Pardon?
But the affidavit which I was required to file here. The last occasion, I gave it during the course of the day. But the affidavit which has come after wedding was effective. I've got a corrected one. I'll file a copy in 10 minutes. I've already sent for filing. But you can take up tomorrow along with the affidavit.
Tomorrow?
Tomorrow.
Okay. Heard. Mr. Mondal, learned counsel for the petitioner, and Mr. Islam for the petitioner. Mr. Islam in which matter? 6997.
Lordship.
Okay. Also heard Mr. Kosik, learned standing counsel for the respondent in elementary education department. Mr. Kosik submits that though the affidavit in opposition was supposed to be filed on 6/2/2026, yet the same was found to be defective, for which the same could not be filed, and that he has filed the affidavit yesterday or today?
Today I have
Today.
sent for filing.
Today.
Lordship will say that I'm filing the affidavit today.
Is filed today, and a press for listing the matter tomorrow then? Tomorrow. Fair enough.
Item number 4.
Oh, the problem at all. Office is for an affidavit by the zone. Okay. Alright. File is full.
Item 4.
There's also a request for a short password posting is coming. Item 4.
You are for the caveator?
See those one.
Okay. Okay, wait for some time.
Obliged.
Item 5.
Wait, please, Your Lordship. I'm compelled to approach Your Lordship, my lord. What has happened, my lord? There was a suit filed by the predecessor in interest of the present plaintiffs. The suit was filed in 1982. It was with regard to a plot of land measuring 4 bighas and odd, along with a house, my lord. Suit was partly decreed. So far as the house is concerned, it was decreed in their favor, but otherwise, other than that, it was not decreed, my lord. Now, we went for demarcation of the land. That has been now challenged in a subsequent suit with the same prayer. Now, they are again claiming title over the same plot of land in the subsequent suit. So, my lord, we filed an application. Initially, we had filed an application under Order 7, Rule 11 for rejecting the plate. Then we filed an application under Order 14, Rule 2 for framing a preliminary issue of res judicata. That was allowed by order dated 22/11/2024.
Hmm.
Now, subsequently, my lord, when that application was again considered, my lord, the learned trial court was called upon to decide that issue on the basis of whatever is available on record. It is to decide the issue of res judicata. Now, my lord, by the impugned order at page 232, 1410, the learned trial court proceeded as if it was deciding the application under Order 7, Rule 11, my lord. Let me first show your lordships the order of 22/11, my lord, page 231. 231 is the operative part, my lord. I'm not troubling your lordships with the details of the orders. If need be, I'll refer, my lord. 231, just the second last paragraph. In view of the above, the prayer to decide the issue of res judicata, issue number 2, as a preliminary issue is allowed. So now the trial court has to decide the issue of res judicata, my lord. Now the impugned order starts at page 232, my lord.
Yes.
I am reading. I'm sorry, madam. I am reading from the third paragraph, right petition number, page 232.
Hmm.
Right petition number so and so that is so and so, the defendant side prayed to frame preliminary issue of res judicata. On 22/11, this is the same order, my lord, which I have just now read. On 22/11, in Misjid, the prayer for deciding the issue of res judicata as preliminary issues allowed. As such, both sides have advanced their arguments as to whether the plaint should be rejected on the ground of res judicata or not. It is stated by the defendants that the subject matter of this suit is the same with that of the subject matter of TS 14, which was decreed on 25/11/99. On going through the plaint of both the suit, it appears that some of the parties in both the suits are same, but not all. The claims of the parties in both the suits are also different. In this suit, the plaintiff has claimed title based on adverse possession and inheritance. In fact, my lord, in the earlier suit also, it was adverse possession was claimed. It was negated, my lord. If need be, I can take your lordship there, my lord. In TS 14 of 1982, plaintiff claimed for title on the basis of purchase and also prayed for recovery of possession. It is seen that although the subject matter of both the suits are same, the parties as well as their claims are not same in both the suits. There is another prayer in the present suit for declaration that revenue authority or district administration cannot enter directly in the suit land without consent of the plaintiff on the basis of the decree dated so and so. It is submitted that without going to the execution process in competent civil court, defendants of the present suit tried to enter into the suit land with the help of district administration, which is illegal, and a decree of the said suit also has not stated about any such recovery of possession or eviction. It is settled position of law that preliminary issues are only issues of law. To reject a case, my lord, to reject a case under Order 7, Rule 11 of CPC on preliminary issue, the court needs to confine on the pleadings of the parties only and cannot go beyond that. Learned counsel for the plaintiff side has cited the decision of the Honorable Supreme Court in so and so, wherein it is held that plaintiff suit cannot be rejected on ground that it is barred by principles of res judicata, as same will require production of pleadings, issues framed, and judgment in previous suit. To compare it with present suit and cannot be done by deciding an application under Order 7, Rule 11, my lord. As only the averments in the plaint itself may be considered at this stage. Learned counsel for the plaintiff has also cited the decision of so and so, wherein it is held that courts should normally dispose a suit on all issues, deciding a suit on preliminary issues an exception only. Learned counsel for the plaintiff has also cited another judgment of so and so, seen. In view of the foregoing discussions as well as the decisions of the Honorable Supreme Court of India and the Honorable High Courts, it is seen that it is not a proper stage to reject the plaint under Order 7, Rule 11 of CPC. First of all, the matter of res judicata cannot be decided without going through the pleadings and issues of both the suits and the decision of the earlier suit. But Order 7, Rule 11 CPC mandates only to confine in the pleadings of the present suits. Now, with the utmost respect, my lord, the learned trial court was the decision to decide res judicata as preliminary issue has already been passed in the earlier order. Now, the learned trial court, while deciding this application, proceeded on the basis that as if it was deciding on Order 7, Rule 11. Now, I had filed an Order 7, Rule 11, my lord, that was withdrawn, and that is recorded in the earlier order. Page number kiman asile? I can show your lordship that, my lord. Page 224. In fact, starts from 223. This is part of the earlier order, 2211 order, my lord. From the decision of the court 223, I am reading last paragraph.
So,
Prior to filing, my lord.
no,
Page
not this
223.
order, the impugn order was passed in respect of the petition under order.
One of the order 14, rule 2, petition was allowed. Now the trial court was required to decide the issue of res judicata, whether the suit is barred by res judicata. Now, but the learned trial court proceeded as if it was deciding an application under order 7, rule 11. It is not an
It
order.
was earlier filed, but it was withdrawn.
It was withdrawn. That is reflected at page 223 and 224. 223, last sentence, madam, prior to filing. Prior to filing this petition by the defendant had filed a petition under order 7, rule 11 on the point of res judicata, and the court heard both sides, and before passing final order by the court, defendant had withdrawn the said petition. So the law which has been applied while passing the order dated 1410, my lord, is the law pertaining to order 7, rule 11. That is an admitted position, my lord. In an order for 7, rule 11, the court is required to look into only the pleadings of the plaintiff. It cannot even look into the defense. But here is a case where the issue has already been framed, res judicata. The earlier order has directed that the issue, res judicata issue, will be decided as a preliminary issue. And this is also unclear, my lord. The learned court says that the res judicata cannot be decided. Now, whether this has been decided against me or the learned trial court will decide it finally, that is also not clear. Because from a perusal of the entire order which I have just now read out, my lord, was the learned trial court has proceeded on the basis that no, it cannot be decided as a preliminary issue. This is my respectful submission. But that part is already over. Now, even if this issue is ultimately decided along with the main issues, my lord, I would not have any objection. But by this order, if it is later on interpreted that no, that this res judicata has been decided against you, my lord, I will be highly prejudiced. That is why I am before this honorable court, my lord.
No, can it be inferred with from perusing the impugn order?
No, because there was
What
no...
the trial court has observed is that the plea of the defendants to reject the plaint under order 7, rule 11 cannot be entertained on the ground of plea of res judicata.
There is no order 7, rule 11, my lord, pending. The order 7, rule 11 has been withdrawn.
Okay, we will set aside the order and remand the matter to the learned trial court again.
My lord. My lord. Let the learned trial court decide the issue of res judicata as ordered earlier by the order dated 2211. Order is there. Your lordship reads the earlier order of 2211, my lord. The trial court has categorically come to a finding that yes, there are similarities. Everything has been considered, and then it was decided that let it be decided as a preliminary issue.
No, that order is part of the record.
Yes, yes, at page 218.
Twenty-second of November, 2024.
Yes, ma'am. Because if in the subsequent order, the court says that I cannot decide the issue, that will amount to reviewing the earlier order.
Heard, Mr. N. Decker, learned counsel for the petitioner. In this petition, under.
This is under 115 of the CPC.
Under section 115 of the Code of Civil Procedure, the petitioner has challenged the order dated
14/10/2025.
14/10/2025, passed by the learned civil judge senior division, Surat, in title suit number 62 of 2012. It is to be noted here that by the impugn order dated so and so, the learned trial court has disposed of Mizje case number
Mistake case number
126 of 2024, 2024, and thereby dismiss the plea for deciding the preliminary issue as to whether the suit is barred by the principle of res judicata or not. Mr. Decker, learned counsel for the petitioner, submits that the predecessors of the defendant,
plaintiffs.
plaintiffs, predecessor of the plaintiffs of title suit number, present title suit
TS number 62 of 2012.
62 of 2012, had instituted one title suit
14 of
title
1982.
suit number 14 of 1982 in respect of a plot of land measuring 4 bigha 1 kata 3 lasses covering dag number 1070 and 1 bigha 1 lessa of dag number 1133 under PP number 147 situated at Sorbai Bandha, Gao, Horusarai Moza, under Horusarai Moza of Jorhat. The said title suit number 14 of 1982 was decreed,
Partly.
partly decreed by judgment and decree dated 25/11/1999, and thereby declared the respondents right only over 2 katha of land with the house thereon by adverse possession, and held that a remaining suit land are belonging to the petitioner. The said judgment and decree was challenged in title appeal number 02 of 2000. But the same came to be dismissed by the judgment and order dated 15/2/2011 and Mizje case number 38 of 2011 on 29/8/2012.
It was a review. Ms. J 838 was a review, which was also dismissed.
Title appeal number 2 of 2000 on 15/2/2011, which was dismissed. Thereafter, one Mizzi case number 38 of 2011 was filed for review of the aforementioned judgment, and the same was also dismissed on 29/8/2008, 2012, and thereafter the impugned judgment and decree dated 25/11/1999 attained finality. Thereafter, the present petitioners being defendant had filed one petition on 6/9/2012 before the circle officer, West Circle, for demarcation of land and showing boundary of 8 bighas, 6 lessas, and 2 kathas, 10 lessas of that number 1133, both PP number 147, situated at Saraigonda Gaon, under Haruhozai Mauza, Jorat. Though initially the respondents took part in demarcation process, but later on they raised objection and filed the present title suit, being TS number 62 of 2012. The petitioners, being the defendant, had appeared and filed a written statement cum counterclaim. And during the pendency of the proceeding, the petitioner had filed an application under Order 14 Rule 2 CPC for framing the issue of res judicata as preliminary issue. And the said application was allowed by order dated 22/11/2024. But the learned trial court, by order dated 14, by the impugned order dated 14/10/2025, has dismissed the said petition by holding that the plain could not be rejected under Order 7, Rule 11 CPC on the ground of plea of res judicata, although it was incumbent upon the learned trial court as it has already framed the preliminary issue, and without deciding the said issue, the learned trial court proceeded with the matter as if it was an application under Order 7 Rule 11 CPC. Mr. Deca further submits that it is a fact that the petitioners have filed an application under Order 7 Rule 11 CPC, but the same was withdrawn, and the same was reflected in the order dated 22/11/2024. Despite the learned trial court proceeded with the matter as if it has passed the impugned order to deal with an application under Order 7, Rule 11 of the CPC. And under such count, the impugned order, according to Mr. Deca, suffers from serious infirmity, and also it caused serious prejudice to the petitioner, and therefore Mr. Deca contended to interfere with the same. Having heard the submission of Mr. Deca, learned counsel for the petitioner, I have carefully gone through the petition and the documents placed on record, and also perused the impugned order dated 22/11/2024. And it appears that the learned trial court on the petition file under Order
14 Rule 2.
Order 14 or Rule 2 CPC has framed one preliminary issue on the point of res judicata. res judicata. And in that way of the matter, instead of proceeding to dispose of the said application, the learned trial court has passed the impugn order as if it has dealt with an application under Order 7, Rule 11 of the Code of Civil Procedure. In that way of the matter, the impugn order suffers from serious infirmities, then the same requires interference of this court. Accordingly, the impugn order dated so and so stands set aside and was, and the matter stands relegated to the learned trial court with a direction to proceed with the matter and to decide the issue of res judicata after affording an opportunity of being heard to both the parties. In terms of above this, CRP IO stands dispose of at this motion stage itself, leaving the parties to bear their own cost.
I'm a back.
So in this revision petition, I am challenging an order passed by the learned court, in fact, the executing court, in a petition filed under section 47 of the Code of Civil Procedure. To the section 47 petition, we challenge the, my lord, identity of the land which is sought to be executed as per the judgment and decree passed by the learned First Appellate Court in the year 2006, as well as that there is nothing mentioned in the decree passed by the First Appellate Court in conformity with Order 41 Rule 31. That is, no decree was drawn as required under Order 41 Rule 31. So that 47 petition was dismissed by the learned trial court. If I may take your lordship to the impugn order at page 165. The lordship has got. We may skip para 1, 2, 3, then 4. In fact, 2 petitions were filed. One under Order 26 Rule 9 for appointment of a commission and Section 47. Out of them, the application filed by the petitioner judgment debtors under Section 47 read with Section 151 of the Code of Civil Procedure 1908 raises objection regarding the vagueness of the decree dated 30/6/2006 passed by the learned First Appellate Court in title appeal number 4 of 2002. Now, if I may take your lordship to the relevant portion of the order passed by the learned trial court, which is available at page 160, 170.
Yes.
Paragraph 20. The lordship has got.
Yes.
Now, there is no quarrel with the proposition of law laid down in the aforesaid judgments, namely that ordinarily it is the duty of the court passing the judgment to clearly specify the reliefs granted in the operative portion, and that failure to do so may render the decree vague and incapable of execution, requiring recourse to Section 152 CPC before the another court. However, before applying the above principles to the present case, this court is required to take note of the specific and binding observations made by the Honorable Gauhati High Court in its order dated 2/5/2025, passed in CRP IO number so and so, which arose out of the very same execution proceedings and concerns the very same decree dated 36 2006. Next, my lord. The Honorable Court, after reproducing the contents of the decree prepared on 4/7/2006, which reads, appeal is allowed with cost, the plaintiff's suit is decreed as prayed for in the plain with cost, the impugned judgment of the trial court is set aside, specifically examine the effect of the words decreed as prayed for in the plain in the context of Order 41 Rule 31 CPC. Then, my lord, next at page 172. paragraph 26, my lord. Finally, it was expressly directed to this court to proceed with the execution of title execution case number 8 of 1994 by executing the decree dated 30/6/2006, and further observe that the executing court shall, if necessary, exercise powers under section 47 CPC to give full effect to the decree so passed. Therefore, the Honorable High Court, in unambiguous terms, held that the executing court has to execute the decree prepared on 4/7/2006. But this term unambiguous may be, my lord, noted in paragraph 28, my lord. However, as noted above, this court finds that the Honorable Gauhati High Court has already examined the wording of the operative portion of the appellate judgment, and the decree has interpreted the expression decreed as prayed for in the plain to mean that all the reliefs claimed in the plain stand allowed, and has held that the decree is executable. Next, my lord. Once the decree has been interpreted and its propriety been verified, this court cannot reopen the same question and re-examine the alleged vagueness of the decree by applying general principles laid down in another case. Also, the judgment in so-and-so were rendered in different factual context. Paragraph 30. Under the present circumstances, this court cannot reinterpret over the interpretation placed by this Honorable High Court on the decree dated 30/6/2006. The decree therefore cannot be termed as vague, as it clearly conveys that the relief sought for by the plaintiff in the plain stand allowed in entirety. Therefore, seeking further clarification of the decree from the first appellate court under section 152 CPC is neither necessary nor warranted at this stage. 31. Hence, this executing court shall hereby proceed on the footing that the decree dated 30/6/2006 grants all the reliefs prayed for in the plain and is capable of execution. Accordingly, the first objection raised by the petitioner judgment debtors on the ground of vagueness of the decree is not found to be valid. Or the learned executive court, my lord, swayed away by the judgment, by the order passed by a coordinate bench of this honorable court. My lord, in my humble submission, before the coordinate bench of this honorable court, the question was not that whether the decree can be executed or not. The question was whether the section 152 petition filed by the respondent herein as a plaintiff in the suit, my lord, is maintainable before the learned executing court, which is the trial court as per them. My lord, the decree was passed by the learned first appellate court. My lord, the facts are something like this. In the year 1982, my lord, the respondent in the capacity of plaintiff filed a suit for declaration of right, title, and interest and recovery of first possession on the basis of a gift deed allegedly executed by the ancestor. My lord, that suit was decreed in their favor. Then we preferred an appeal. In the appeal, my lord, the appellate court remanded back the matter, my lord, back to this trial court to decide the suit, my lord, afresh. My lord, after remand, the suit was dismissed. Then they preferred an appeal, my lord. In the year 2006, the appellate court decreed their suit. My lord, if I may take your lordship to the first appellate court decree for a moment, which your lordship will find.
Okay. Mr. Goswami, you are for the respondents here.
My lord, for respondent.
Okay.
It's a long pending case, my lord, the suit of 77.
Yes.
My lord, the Honorable High Court, my lord. the
No,
judgment, if
you
you
tell
look
me,
at
are you
the
ready to argue the matter?
My lord,
We can hear the matter today.
my lord, it may have, because my lord, it's a pending case for 77, my lord.
Okay.
May have, my lord.
Okay, yes.
My lord, the first appellate court judgment, your lordship will find at page 32. It is passed on 30th day of June 2006.
Page number?
Page number 32 is the, my lord, starting of the judgment. I will not trouble your lordship to, going through all the, my lord, paragraphs of the judgment, just the relevant portion at page 57. The
Yes.
order, my lord. Paragraph 29. In the result, I find that the plaintiff succeeds in his case. The plaintiff's suit is decreed as prayed for in the plain with cost. The impugned judgment and decree of the trial court is set aside. Appeal is accordingly allowed with cost, my lord. Well, this is the decree. This is the judgment passed by the first appellate court. There is no explanation as to how, my lord, the decree has been, my lord, formulated, my lord, framed as required under Order 41, Rule 31. But decree must specify the reliefs, my lord, that has been granted by the court, my lord. Then we filed a regular second appeal, my lord. The regular second appeal has been dismissed on a point that they have succeeded in proving the gift deed executed in their favor by the father, my lord. So that was the moot question before the learned, my lord, a coordinate bench of this honorable court while deciding the second appeal. Well, the second appeal was dismissed. Now they put the, my lord, decree into execution. In the execution, my lord, we filed a petition under section 47, the first petition, saying that the decree is vague. It doesn't specify the reliefs that has been granted by the court, and the description of the suit land, my lord, does not match with the land that we are under possession. But that 47 petition was decided. Before that, my lord, the 152 petition they have filed for correction of the decree that was rejected by the learned trial court. They preferred an, my lord, civil revision petition before this honorable court. And this is the whole basis, my lord, on which, my lord, the entire proceeding of 47 was dismissed, my lord. If I may take your lordship to the judgment passed by this honorable court in a petition filed under Article 227, challenging the order passed on a petition filed under section 152. The page number is 118, my lord. My lord, the second paragraph, this is the introductory paragraph. If I may read, my lord, page 118. My lord, in this petition, the learned coordinate bench, my lord, was deciding a question as to whether a petition filed under section 152 before the learned trial court was, my lord, maintainable or not. Because admittedly, they put into execution a decree which was not in existence. My lord, if I may repeat, my lord, in the year 1982, a first decree was passed in their favor, which was challenged by us. And on challenge, my lord, the learned first appellate court remanded back the matter to the learned trial court. On remand, my lord, the learned trial court dismissed their suit. Now they were trying to execute the decree as mentioned in the 1982 suit, which was not in existence. And that's why the learned trial court came to a finding that section 152 petition is not maintainable for the simple reason that the 1982 decree was not in existence. Because in the year 2006, there is a decree passed by the learned first appellate court in their favor. And this is the decree to be executed by the learned executing court. And that fact has been clarified by this honorable court in this civil revision petition, my lord, which I am going to read, my lord, this paragraph 2. The petitioner herein has approached this court by challenging the order dated 18/12/2024, passed in Midjay case number 70 of 2023 by the learned court of the civil judge number 1, Dorong, Mongoldoi. It is seen that by the order dated 18/12/2024, the application so filed by the petitioner under section 152 of the Code of Civil Procedure 1908 was rejected on the ground that the learned trial court could not have made correction to the decree dated 23/1/1982, inasmuch as the decree was passed by the learned court of the civil judge Dorong, Mongoldoi, presently the learned court of the civil judge senior division Dorong, Mongoldoi. Then, my lord, the relevant, if I may take your lordship to paragraph 11 at page 121. Be that as it may, the lordship has got. It is also pertinent to note that the petitioner herein has filed an execution proceeding being titled execution case number 8 of 1994 on the basis of the judgment and decree dated 23/1/1982. Initially passed by the trial court, taking into account the subsequent events, the execution proceedings ought to have proceeded in terms with the judgment and decree dated 36/2006, my lord. They, in the execution petition, my lord, they mention about the judgment and decree passed in the year 1982, which was not in existence at that point of time, my lord. Because it was set aside, remanded back, then a fresh decree was passed in the year 2006 by the learned first appellate court, which was decree dated 36/2006, passed in title appeal number so and so, which was confirmed by this court, but on a misconceived notion the learned trial court, which is also the learned executing court, was proceeding for execution of the decree dated 23/1/1982, which was not in existence. The petitioner also on such misconceived notion sought for correctness of the decree dated 23/1/1982, and the judgment debtor had also raised objection as regards the maintained executability of the decree, taking into consideration that the decree sought to be executed was the decree dated 23/1/1982, wherein in the decree so prepared, the patta number was mentioned as patta number 3 and not patta number 39. Well, original patta number is patta number 39. They have mentioned in the execution petition the patta number 3 as per the decree drawn in the year 1982. On account of the above, the present proceedings are before this court. Well, then the court relied on the Pratibha Singh and another judgment which says the decree should specify the relief that has been granted by the learned first appellate court or the trial court. Then paragraph 15, my lord. 123. Considering the above, the instant proceedings stands disposed of with the following observations and directions. The filing of the application under section 152 of the Code for correction of the decree dated 23/1/1982 in title suit number 23/1977 was misconceived, taking into account that when the said decree is not in existence, the question of seeking rectification or correction of the contents of the said decree does not arise. The learned court of the civil judge, number 1 Dorong Mongoldev, who is also the learned executing court, shall proceed with the execution of the title execution case number 8 of 1994 by executing the decree in terms with the judgment and decree passed by the learned first appellate court dated 36/2006. This is the observation which was relied on by the learned executing court to dismiss my section 47 petition. But the fact and the issue involved in the civil revision petition was something else, my lord. Here the question, the honorable court was deciding a question whether section 152 petition before the learned executing court for correction of a decree which is not even in existence was correct or not, my lord. The issue, my lord, was different, and the learned executing court, my lord, swayed away by the judgment and order passed by this honorable court, this judgment, saying that this honorable high court has clarified that the judgment and decree passed by the learned first appellate court to be put into execution. Well, here the question of identity of the land was not raised. The issue was something different. Here in the 47 petition, the second 47 petition, my lord, section 47 petition, we raised the specific question regarding the identity of the land. That's why, my lord, we sought for appointment of a commission. Well, the Honorable Supreme Court is very clear. When there is a vagueness in the decree, when the identity of the decretal land cannot be, my lord, ascertained, it is always appropriate to appoint a commission. My lord. We are not trying.
But how the decree is vague?
Well, a decree doesn't specify the relief which has been, my lord, granted by the court, my lord. The decree only says it is decreed as prayed for in the plaintiff. Now, the Pratibha Singh judgment, my lord, Pratibha Singh judgment is very clear. Honorable Supreme Court has laid down the law.
No, that's all right. As prayed for in the plaint. What is prayed for in the plaint?
Well, various things are we pray many things in the plain, my lord. Whether it is possible for the court to grant all the reliefs, my lord, there are vagueness in the plain prayer portion also. That has been clarified by the Pratibha Singh judgment, my lord. And the section 47 petition was not decided on merit. My lord, my moot question before this honorable court, with due permission, my lord, the section 47 petition was never decided on merit. Well, whether my claims are, my lord, ascertainable or it is, my lord, non-tenable, it has to be decided on merit. But the learned executing court relied on the judgment passed by this honorable court, which was deciding a question as to whether section 152 petition before the learned executing court was at all maintainable or not, my lord. My lord, as a, my lord, litigant, my lord, I have the right, my lord, to adjudicate or to place my grievances before the court, my lord. My grievances either has to be rejected or allowed, my lord, but on merit. Well, in the section 47 petition, the order just now I have read, my lord, there is no finding on merit of the case, my lord. What I sought for, just a clarification, my lord. As a judgment debtor, since we are residing there, if, my lord, a wrong land is executed in future, my lord, I will be affected. And that's why, my lord, this honorable court has also clarified the executing court will go as per section 47, any claims and objection raised under section 47 has to be clarified, my lord. And the Prohibitions judgment is very much clear that the decree must specify the reliefs as claimed for. But that's why the importance of decree comes in, my lord. Otherwise, only the judgment will do. My lord, whenever we challenge the, my lord, judgment, we challenge the decree in any forum, my lord. Be it in the first appellate forum, be it in the second appellate forum, my lord, we challenge the decree. A decree, my lord, has its own importance, my lord. But when the decree is silent about the reliefs that has been granted, well, we have raised the objection, but they didn't file any petition under section 150 to clarify from the first appellate court that what is the decree, what is to be executed. Only says prayed for, and that's why one of this Prohibitions judgment. Well, paragraph 12.
No, this is not Prohibitions.
No, my lord, it is Lakshmi, yes, it's Lakshmi Ram Bhuya. I'm sorry, my lord. Paragraph 12, my lord. In the case at hand, a perusal of the reliefs prayed for in the plain shows that the reliefs are not very happily worded. There are some reliefs which may not be necessary or may be uncalled for, though prayed for. The reliefs may have been considered capable of being recast or redefined so as to be precise and specific. Maybe that the court was inclined to grant some other relief so as to effectually adjudicate upon the controversy and bring it to an end. Nothing is spelled out from the appellate judgment. The trial court on whom the obligation was cast by the second appellate judgment to draw up a decree was also, as its order shows, not very clear in its mind, and thought it safe to proceed on an assumption that all the relief sought for in the plaint were allowed to the plaintiffs. The learned single judge allowing this second appeal should have clearly and precisely stated manner of relief in which the plaintiffs were found to be entitled in his, my lord, case. Well, this is the finding in the case, my lord. Here also, the first appellate court did not specify or did not draw up the decree in consonance with Order 41, Rule 31. And that's why, my lord, Honorable Supreme Court stepped in, saying that no, all the reliefs, my lord, it has to be specified, and that's why there is a.
Where is the decree?
My lord, decree your lordship will find. Page 32 is the judgment, and the decree your lordship will find page 57. This is the order. And the decree is drawn at page 60. It says appeal is allowed with cost. The plaintiff suit is decreed as paid for in the plain with cost.
And where is the plaint?
Well, a plaint, my lord, page 22. Copy as well. Page 21, it starts from page 21. Therefore, the plaintiff prays for declaration and decree of right, title, and interest of the plaintiff of the co-scheduled land and co-scheduled land, for decree of khas possession of the plaintiff over the co-scheduled land and co-scheduled land and go-schedule after evicting the main defendants with their men and materials along with their families, for decree of khas possession of the co-scheduled land in favor of the plaintiff on which go-scheduled house or any house of the defendant is found or as such proved, then after demolition of their house or houses, for decree of the cost of the suit by the main defendants, for decree of any other reliefs, benefits if entitled to by the plaintiff as determined by this honorable court, for decree against the main defendant after adjudication the plaintiff is decreed with the co-scheduled land and the co-scheduled house with khas possession thereof, so that the main defendants cannot at any time can dispose the plaintiff in any way, though the plaintiff had not sought for any relief from the proforma defendant, but if the proforma defendant narrate speak of against the plaintiff, well, this is also a prayer, was a prayer that has been allowed. They may also be treated as main defendants and the suit would proceed against them, which may kindly be ordered than schedule of the land.
No, is there any dispute regarding the schedule of the land?
Yes, my lord. And this is the dispute, my lord, we raised in the section 47 petition that was not adjudicated. Learned executing court, my lord, swayed away with the order passed by this honorable court in a petition where the issue involved was something else. This honorable court was deciding a question as to whether a section 150.
Mr. Biswas, you tell me, you see here the Dag number, patta number, and also the land measuring 2 bigha, 4 katha, 1 lesa, this has been mentioned. So is there any dispute in respect of the Dag number, patta number?
Dag number, patta number, my lord, this land consists of a large area. Out of that, they are claiming 2 kathas, my lord. It's a joint property, my lord. Both of us are, my lord, the descendants from the same ancestor. They are saying that there is a gift deed, and the boundary description given in the, my lord, plaint, my lord, is not correct and proper. And that issue we raised specifically in the section 47 petition. That's why we filed a separate petition under order 26 rule 9 to ascertain. It will take hardly 20 days, my lord, to appoint a commission and ascertain. That will solve the matter for once for all. If any case, my lord, I am being dispossessed from a land which is not even, my lord, decreed, well, it will cause irreparable loss and injuries to us. And what we have prayed before the court, only to ascertain the identity of the land. And the Supreme Court is also very clear that wherever there is a dispute, the order 26 rule 9 can be adjudicated,
Supreme Court is also clear that a decree has to be executed within a period of 6 months.
Well, it is in the context of a matter where the cases are pending without there being any stay order, without there being any order from any higher authority, higher forum. That is a general judgment passed in for general cases where the executing court is delaying the matter, or the clients are or the litigants are delaying the matter. There the specific or general direction has been passed. It is not in the context of the matter when there is a dispute regarding the identity of the land. Well, I have read the judgment. The judgment says, my lord, some execution proceedings are being delayed for several reasons, my lord, for this reason or that reason.
That judgment is available with you?
But not right now, my lord, with me, my lord. I can place it. I can give, my lord. Before that, my lord. Yeah.
So how long this execution proceeding is pending before the?
Recently, 23, in the year 23, the learned, this honorable court.
Today we are in 26.
My lord, this judgment, my lord, this RSA judgment was passed. That was not due to our fault, my lord. In the year 2006, we preferred and second appeal before this court, my lord. Automatically, there was a stay granted by this honorable court. And the hearing took place, my lord, in the year, but it was decided on 21/4/2023.
So regarding this dispute in respect of the Dag number and patta number, whether you have raised any objection before any of the forum?
Yes, my lord. Section 47.
No, earlier.
Earlier regarding identity of the land, my lord, in the, my lord, not in very much, my lord, we have raised specifically that this is not, because we came to know when they put the decree into execution.
No, you have already contested the case.
Yeah, I was contesting the case, my lord, when
whether you have taken any such plea in the written statement.
Yes, but the suit was dismissed, my lord, well, saying that was a gift deed. They are relying on a gift deed. We took a stand against the gift deed only, my lord, because their entire case based on the fact that the gift deed has been executed by the father, my lord, late father. And we're saying that gift deed could not have been executed by the father, my lord, in favor of a son, my lord, single son, because there are other sons also. My lord, there is no theory of, my lord, denouncement in the Hindu law, my lord. I am not on that, my lord, because it has been decided by the court, my lord. But be that as it may, well, when we have raised in the section 47 petition, the section 47 empowers the court to decide the question, my lord, involved.
No, there is no doubt about it. There is no doubt about it. But the question is, how far it is justifiable if you have not raised any such question before any of the forum earlier?
My lord, but
Whether
we
your written statement is part of the record?
no, yeah, my lord, it's a very old, old pending matter 1982. So, my lord, the quality of the papers were also not very good. So, we could not annex it, my lord. The plaint and the past appellate court judgment.
Can you produce it day after tomorrow?
Yes.
You can. Okay, and also you produce the decision of the Supreme Court in
Yes, yes.
respect of
But I can
execution
find
of
it.
the decree.
Yes.
Okay, Mr. Goswami, on Friday.
That earlier that never raised regarding identity or ambiguity, that I never raised in any case. I'm not that he did it. Matter end.
Okay, we will say.
That has not, that is finality.
So we are listing the matter on Friday. Caveator, caveator we heard, caveator decides, heard Mr. Sedisas, learned counsel for the petitioner, and also heard Mr. Goswami, learned counsel for the respondent. List the matter on Friday. On that day, Mr. Disseminate, learned counsel for the petitioner, shall place before this court the written statement filed by it before the learned trial court, and also the decision of Honorable Supreme Court in respect of execution of the decree within a period of 6 months. Friday.
Much obliged.
May it please your lordship. My lord, this is against the impugn order dated 15/12/2025. Lordship will find page 14, my lord, annexure 1. But in this case, my lord, this petitioner, the plaintiff, my lord, he filed the suit for, my lord, right title, interest and confirmation of, my lord, of land, of the scheduled land, my lord. My lord, meantime, my lord, the defendant also filed, my lord, WS. They also filed, my lord, counterclaim, my lord. And after that, my lord, this petitioner plaintiff, my lord, filed a application for amendment of the, my lord, plain, my lord. That petition has been rejected, my lord. On two grounds, my lord. One is delay, my lord, and another is, my lord, it will change the nature and character of the
And
suit.
what it says, the suit is pending now.
My lord, suit is pending for, still issue has not been framed, my lord. So trial has not been commenced, my lord. So for the first question, my lord, delay, there is no delay, my lord. Lordship, it is clear from the order 6 rule 17, my lord, which speak that, my lord, if after start of the trial, if any application filed, that, my lord, the question of delay or, my lord, explanation comes, my lord. I have categorically stated in paragraph 4 of my petition, my lord. It is only for necessary order, my lord. An issue has not been framed, my lord. And as per judgment of the Honorable Supreme Court, my lord, when trial start, when issue, then trial has started, my lord. And the order also cryptic one, my lord, let the trial court after, my lord, explain the facts, directly come into conclusion that this is a delay and, my lord, it will change the nature and character, my lord.
Where is that decision of the Supreme Court?
Yes, my lord. In Baldev Singh, my lord, para 17.
No, there is a very recent decision of 2024 or 25,
Lordship.
early part of 25.
Okay. My lord, so far, my lord, proviso itself clear, my lord. Can I read, my lord?
No, no, proviso, it is clear, that's all right, but I want that judgment of the Supreme Court,
Lordship.
where it is stated all amendments should be allowed. It has been held by the Supreme Court.
Yes, my lord.
If the amendment is necessary to determine the real question of dispute.
Yes,
between
my
the
lord.
parties.
This also discussed in this judgment also, my lord.
No, no, the
I,
basic judgment.
I'll see, my lord. Today, my lord, notice may be issued, my lord. Let other party come. And in the
No,
meantime, my lord,
if we can dispose of this petition without issuing notice,
Lordship, that.
heard
thought-
Mr. Uddin, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 15/12/2025. Passed by the learned civil judge, senior division Srigami in Miss Case number 81 of 2025. In petition number 567 of 567 struck 4 dated 18/12/2024. Under order 6 rule 17. Read with section 151 of the Code of Civil Procedure. Arising out of title set number 32 of 2023. It is to be noted here that by the impugn order dated so and so, the learned trial court has dismissed the petition filed by the petitioner for amendment of the plaint. After hearing Mr. Uddin, learned counsel for the petitioner, it is provided that recess list the matter on Monday,
Yes.
next Monday,
Monday.
on which Mr. Uddin shall produce before this court the latest decision of this of the Honorable Supreme Court in respect of amendment of plaint.
All right.
Number 7.
May I please, Lordship? My lord, here in my lord, petitioner filed a title suit, which was dismissed, decreed against him. And challenging that dismissal decree, he approached before the first appellate court, referring an appeal. That in that appeal was admitted and directed to take steps. And in that situation, he failed to take steps, and subsequently he absent. Due to his absent, case was dismissed for non-prosecution. And subsequently, the petitioner filed a restoration petition. That restoration petition was dismissed. Before this court, I am here for allow this petition just to decide the matter on merit and restore the appeal, my lord. Impugned order, my lord, at page 69. And first appeal was dismissed for non-prosecution. That order at page, my lord, 54, my lord. Annexure 6.
Page number
54, my lord. 54 para 5. No petition is also filed, praying for taking steps by appellant. Hence, the appeal is dismissed for non-prosecution.
So for 1 year, you have failed to take any step.
About 1 year, my lord.
Then What wrong with the order?
My lord, in that case, my lord, advocate for the petitioner has not taken steps,
No,
my
no.
lord.
Now you cannot blame the advocate.
I'm not blaming, but that is happened, my lord.
And second order?
Second order, my lord, page 69. Operating part at page 70, my lord. There are 7.
So you see what ground you have taken due
Yeah.
to misposting of the learned advocate's diary.
Yes, my lord.
Huh?
Yes, my lord. That is on the, when
Hmm?
case was, appeal was
So
dismissed for non-prosecution,
misposting was for 1 year.
on the last occasion,
Can it be accepted?
in the, on the date of dismissal for non-prosecution, the advocate for the petitioner was absent. And subsequently in the petition, my lord, taking ground that he's posted the matter in his diary wrongly. In this case, my lord, lump sum cost may be imposed and
No, no, no.
are the matter, my lord, married, my lord.
Well, issue notice. Let notice go at this instance. Heard Mr. K. U. Ahmed, learned counsel for the petitioner. This petition under Article 27 of the Constitution of India, read with Section 151 of the Code of Civil Procedure. The petitioner has challenged the order dated uh,
15/11/25.
order dated 15/11/2025, passed by the learned.
Civil
by
Judge
the
Senior
learned-
Division Forfeit.
Learned Civil Judge Senior Division in title appeal number 34 of 2023. Peruse the petition and the documents placed on record, and also peruse the impugned order dated 15/11/2025. Let notice be issued returnable in 4 weeks, step by speed post and also by usual process within a week from today. This is the matter after 4 weeks. We'll see. Let the other side appear.
Obliged.
36.
Nepali Lordship. Lordship, basically this revision has been preferred not against the decision but decision making process. My lord, there is a golden principle, 3 are applicable in case of, my lord, dealing with the situation of injunction. Now, Lordship, kindly see that I have applied for a, my lord, petition along with the injunction petition. Now, in course of, my lord, hearing of this injunction petition, I have been directed to file a written submission, my lord. Now, based on that, my lord, I have submitted a written submission that contained in page 97, my lord. Now, I have 97, madam. Annexure to 97. Last part.
Yes.
Now here, Lordship kindly see column 2, 3 contain with the situation of prima facie case, column B is balance of convenience, and C is irreparable loss. Now Lordship just take for a moment prima facie case, column 2. The contention, again filed letter dated 21/8/2025, the respondent number 2 express his intention to effect the existing shareholder will have to the first right to supply proportionality in page 69. Now Lordship, the rest are the similar line. Just take turn to page 98 impugn order. Paragraph 4. It is submitted by the learned counsel of the applicant that the letter dated 13/8/2025 issued by respondent number 3 in page number 60, column 31, the petitioner holding majority so and so, so and so. Now, Lordship, whatever I have written, that cut and paste, my lord, entire material has been put here on. And afterward, Lordship, kindly see, page 99, impugn order, how dealt with. Column 11. Upon consideration of the entire records, evaluate an argument advanced by the learned counsel for the appellant, this tribunal is of the view that no prima facie case and balance of convenience exists in favor of the applicant. Since no prima facie case exists in favor of the applicant, therefore, the prayer of applicant for interim relief is ever rejected. My lord, there is no single instance out of which my lord mentioned that what prima facie case the learned tribunal has not found. And my lord, irreparable loss has been totally bypassed. And above that, my lord, from paragraph 4 to, my lord, 8, cut and paste, my lord. If this kind of order would be passed, what impression will go in public domain, my lord? The cut and paste policy has been highly deprecated by the Honorable Supreme Court in repeated citations, my lord. It is purely a case of injustice, my lord. There is no any single narration, my lord.
Let notice go at this.
My lord, this order may kindly be stayed, my lord.
They will be considered later on. Let the other side appear.
But my lord, the thing is that, my lord, I have I am, my lord, for seeking interim prayer. Lordship, page 90, my lord. My lord, behind my back, my lord, by following all the laws, my lord, they have now proceeded further, my lord, to issue rights here, my lord. My only thing is status quo be maintained, my lord, nothing more. Let them come, my lord, so date may be given, we'll take service.
Let notice go in both the matter.
My lord.
Let notice go in the interim pair also.
My lord, status quo required, my lord. Otherwise, my lord, they will change the entire structure, my lord.
No, no.
That is the problem. Otherwise, I would have not pressed, my lord.
No.
This, my lord, only that status quo may be maintained, my lord.
Status quo also an injunction.
My lord, next week, my lord, this matter may be taken up. We'll take a step, my lord.
No. Heard, Mr. Samoria, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the order dated 5/2/2026 passed by the learned National Company Law Tribunal Gauhati bench in CP/2/VB/2026. It is it is to be noted here that by the impugn order dated so and so, the learned tribunal has dismissed the pair for interim relief. After hearing Mr. Somoria, learned counsel for the petitioner, and also considering the facts and circumstances on the record, and also the impugn order dated so and so, this court is inclined to issue notice to the respondent returnable in where the other party is residing?
My lord, that party resides outside Assam, my lord.
Outside Assam within 4 weeks. Step by speed post and also by usual process.
My lord, a registered post, my lord.
Speed post. By speed post. With AD. Within a week from today. Leaves the matter after 4 weeks. Issue notice in IA in respect of the interim pair also. Leaves the matter after 4 weeks.
status quo is required, my lord. Otherwise, my lord, I would have not pressed, my lord. I'm not seeking, my lord, that only, my lord, this can be, my lord, that
Mr.
I can,
Komodia, you say.
my lord, only thing is
status
other
quo
action, my lord.
is also a kind of injunction.
Right, my lord.
And
My
without-
only anxiety, my lord, kindly seek for a moment. My lord, if
Hmm.
suppose this, he will be given a free hand, my lord, then he will change the entire structure of the company. He will
No,
be
we
big-
can,
highly be
fix a very
prejudiced.
short date, but you have to serve notice upon them.
Till the returnable date.
Till return of my status quo, my lord. Otherwise, lordship, nothing will happen, my lord, wrong,
Next
but
item.
I will be prejudiced,
No,
my
no.
lord. Balance of convenience lying in my favor, my
No,
lord.
no.
Kindly see.
Item number 8.
Oh, later. None appears for the parties, none appears for the appellant on call, lays the matter after 1 week in the event of subsequent non-representation of the appellant, appropriate order shall follow.
Item number 9. Below I am for respondent payment to applicant I've not received the copy of agreement itself, LCR, etc. Steps.
None appears for the appellant on call. How about Mr. Agoral, learned counsel for the respondent number 1?
Mark Clement.
Respondent number 1 present.
Copy of appeal memo. I've not received.
Party absent.
So that to furnish to them.
No, unless the party present, how can we direct them? Allege the matter after 1 week in the event of subsequent non-representation of the appellant, appropriate order shall follow.
Item number 7.
In this case, we have filed a joint compromise petition.
Item number 72. 26 Lord. The matter has been immediately prepared for 26 plus. Number 1, you can be paid 20 lakhs and respond to 4. Father of the deceased, 6 lakhs.
What was the awarded amount?
6 lakhs.
34, 34. No, filed.
26 lakhs, 34,000.
And you have compromised at
26 lakhs.
Oh, you said this appeal is yet to be admitted. Whether the parties are present before the court today?
No, Lord. The file a joint compromise petition. We filed a joint compromise petition It's an appellant quantum and he is representing the claimants, lordship. Basically, only claimants are required to be there.
Mr. Goswami, you see, the appeal is yet to be admitted.
That's it. It's just today it can be admitted and next week a date can be fixed for for hearing of a petition. It will be admitted today. I also we are admitting.
So without admitting the appeal, how can we pass this order for compounding the case?
No, sir, today, the appeal may be admitted today. It may be again under date may be fixed for compromise petition. I also delay period we are settling the matter. Thanks to. Without admission, in the serial number of the appeal.
Without admission of?
The appeal, it's done, lordship. Something. Compromise petitions are. Filing number. Even at the delay stage, compromise petitions are filed.
Without registration of the MSc appeal?
Yes, lordship. On the filing number itself and IA number.
Where is that order?
No, it is done, lordship. Even I have settled a lot of
only
cases.
one paper.
But without registration of the appeal?
Yes, lordship.
Maybe, but I will not do it.
Yes, lordship. I am not pressing it, lordship. The matter may be admitted today and under date may be fixed for lordship compromise petition. Because petition is already there.
No, compromise can be a ground for condoning the delay. But that too. Anyway, heard Mr. Goswami, learned counsel for the appellant. This appeal under section 173 of the MB Act is directed against the judgment and award dated 28/8/2025 passed by the learned member MSCT Kamrup in MSc case number 25 of 2022 under section 166 of the MB Act. It is to be noted here that by the impugn judgment and award dated so and so, the learned tribunal has awarded directed the appellant herein to pay a sum of rupees 26,34,507 rupees, being the compensation with interest at the rate of 8% per annum from the date of filing of the claim petition till realization. Where is the memo of appeal and the grounds mentioned therein? And also peruse the impugn judgment and award dated so and so, so and so. Admit. Issue notice to the respondents. Returnable in 2 weeks. However, no formal notice is required to be issued since Mr. Agoral entered appearance and received notice. However, the copy of memo of appeal be furnished to him during the course of the day. Mr. Goswami and also Mr. Agoral. No, Mr. Goswami, learned counsel for the appellant, and Mr. Agoral, learned counsel for the respondent, submits that the parties have effected a compromise, and to that effect, one joint interlocutory application, being I number 272 of 2026, is also filed before this court. And as such, the entire matter may be disposed of. Taking note of the submission of learned counsel for both the parties, it is provided that a registration is the matter after 2 weeks, on which
Intermittent notice to respondent 5 and 6 only.
respondent number 5 and
Notice is required to be sent, lordship, not required. Because
whether all the respondents are represented by Mr. Agoral.
no, he represents only 1 to 4.
1 to 4. How
I
many
will speak
respon-
to the owner and driver. And in a case of quantum, they can be struck off, lordship.
Okay. Last or here, আগতে লিখি লম। Mr. Goswami, learned counsel for the appellant submits that the name of respondent number 5 and 6, who are the driver and owner of the offending vehicle, may be struck off from the array of this appeal, since in the present appeal only the quantum is silenced. Quantum is being silenced. Accordingly, taking note of the submission of Mr. Goswami, learned counsel for the appellant, the name of respondent number 5 and 6 are struck off from the array of this appeal at the cost and risks of the appellant. List the matter after 2 weeks on which
One date may kindly fix.
correct.
27.
Mr. Agoral, learned counsel for the respondent, shall ensure presence of the respondents, all the respondents before this court. You ask them to remain present in the court, we will see. So we'll resume after 5 minutes.
We have those documents, Anna, which says what is the quantum of money that the bank is supposed to pay to a person who loses something in the bank locker.
The quantum of gold mylord in the locker has not been disputed by them before the state commission.
No, we have disputed it. Absolutely. We have
Pilot,
added the paragraph. We have
eh,
absolutely disputed. No, that is not correct.
DW2, he has
We have
admitted,
absolutely
he has
disputed.
admitted that there may be that much of goods which we have stated. That is his statement in the cross.
Suppose
DW2.
somebody, let us take an example. Somebody comes up, he keeps something, suppose a paper, or he keeps it empty. Now comes up and says, no, see, my locker is broken or it is open. Now you need to pay me 1 crore, there is 1 crore of gold. That cannot be the mandate. They need to go to a civil court. That is the proper forum. They come up before a forum which says, no, pay this quantum of gold. But that quantum of gold has to be quantified and proved. And that is the civil court, which the Supreme Court has opined. Because while passing the order, the national forum also, they say it is on the higher side. Still, I think they have given 10 lakhs only for the reason that let us give 10 lakhs, let them get something. Because normally in all the cases, we normally pay 50,000, 10,000, 25,000. That is the normal amount that we regularly see.
I am placing my lord another judgment, my lord, National Commission, where my lord, the amount compensation amount given by the State Commission has been upheld by the National Commission. Where my lord, whereby my lord, the gold which has been stolen from the locker has been recovered. Thereafter also my lord, 30,000 lakhs rupees has been compensated by the my lord, the State Commission, and that has been upheld by the National Commission after this Amitabh Dasgupta judgment, my lord. This is the judgment of 2022, whereas Amitabh Das is the judgment coming to 2021. This is the judgment of 2022 of the National Commission, my lord, whereby 30 lakhs rupees which has been compensated by the, my lord, the State Commission has been upheld by the National Commission. It was.
But I
30 lakhs
don't know what
rupees,
is
my
the
lord.
facts of those things.
The facts is,
But
I
that
have
is the
stated
National
the
Commission
fact.
judgment. This is the Supreme Court judgment. Your Honor.
Whereby my lord, the stolen property has been recovered and it has been some of the jewelries were distorted and some were found in the original condition also. And in spite of that, my lord.
No, whether there was any quantification in respect of the deficiency of service in the earlier judgment?
No, my lord. What they have pleaded, the court took as it as a gospel truth and wrote it 23 lakhs
that sum or sum of money. Because you see the prayer portion also, exactly same amount they have given. So in the prayer portion also, Your Honor will see.
And the quantum has
happened?
not been disputed, my lord.
But-
It has taken into
No, no, they have
consideration, my lord.
disputed it. I can show absolutely. In unequivocal terms, my lord, we have disputed it. And see, my lord, 148 under Contract Act is absolutely clear. It is not under bailment. It was only when the goods which I showed, Your Honor, when Peshawar to India it had brought, they had given a slip and said that these are the contents, please wait it and see. Once it is under bailment, I bow down and say that yes, I'll pay. But I am not under a bailment. That is why the RBI guidelines I'll show, which shows that what is the quantum of money that a banker is supposed to pay to a local holder if there is any dispute or if it is broken. Otherwise, the RBI guidelines would not be in contravention to 148. It cannot be. Because it was absolutely in unequivocal terms, we said that no, we are not. Your Honor, everybody who operates a locker never goes and disclose to the bank that, see, these are my locker, please verify, and then I lock it. He opens it up, he keeps
No,
it.
we are not on that point.
And Your Honor, the judgment which my learned friend had shown, that also 30 lakhs in terms of mental agony, not on for this one.
Simply saying that, my lord, it is on the higher side that.
If you honor will see para 28, their prayer portion in the original application, absolutely 28 lakhs 85,600 for ornament, 5 lakhs for mental stress, and 2 lakhs for harassment. It comes to 30,85,600. Para 28. And that is that 23.
Page number?
28, my lord. Down below.
That is right.
Breakup as given below. My lord, have got it.
Yes.
Value of the ornaments and jewelry is 23 lakhs 85,000, mental stress 5 lakhs, and harassment 2 lakhs. Total comes to 30.
Whereas the code below has given her for 50,000 and 10,000 for as cost of litigation and my lord for mental harassment, not what I have prayed for.
My only submission is that, my lord, as far as the gold is concerned, the quantification of gold is disputed and we are not the bailees under 148. So, in terms of the gold that they are portraying that we have say 30 lakhs, 20 lakhs or 25 lakhs of gold, that cannot be quantified and that cannot be given by a consumer court. It has to be given by a civil court. That is the settled principle of law as per the latest Supreme Court judgment. So, on the basis of that judgment, my lords, the National Commission had come up to the conclusion, no, I cannot give for the quantification. Whatever is required, you please go to the civil court. And they ought to have gone to the civil court. Now, after taking the 10 lakhs of rupees, my lord, they come up and say, no, now this is also not the actual amount. And how they have quantified, they have given it on their own letterhead that this is the amount.
That is proved by the way of
No,
evidence.
it is not proved at all. That is absolutely not proved. And the Consumers Forum is not the forum to prove those disputed articles because we are not under 148.
Lordship may come to page, my lord, 101. This is the cross-examination of the DW2, my lord, the locker in charge.
My lord, it's under 227. My lord, may get into all this.
My lord. One 101. I was not the locker in charge on the day of occurrence of the incident. I was not serving in the Gauhati main branch at that relevant point of time. I have not gone through the record of the case before giving the evidence. I do not know the actually happened on that day. I do not know who was the locker in charge of at that period. There may be jewelries and ornaments in the locker as stated by the complainants. After using the locker hire used to close the door of the locker, and if the door of the locker is not properly locked, the key of the hire does not come out. I cannot say the deputy manager PBD officer in charge has given the certificate of the locker operated during the day has been found properly locked or and verifying
The lower court, if you ask the witness, you are not aware as to what is there. He says, yes, I am not aware whether there was gold or not.
But the question is how the commission has segregated this 10 lakh rupees from rupees 23 lakhs
In
85,000.
that facility, well, I may say that this may be remanded back and let them ask how you have segregated to the national commission. If your honor feels that 10 lakhs, I am not satisfied how they have segregated it. This can be remanded to the national commission, then let them decide how 10 lakhs you have segregated, let us know. Because whatever there is an order, we can only.
And
take that.
how can they say this amount? This 10 lakh rupees would be justified for deficiency of service.
That is just and reasonable manner.
Hmm? No, it may be reasonable for you, but it may not be reasonable for the other side, no? It would be reasonable for you if no amount was awarded by the commission to the petitioner.
Lordship, in that eventually I have no answer to Lordship. Absolutely, my lord, the 10 lakh that has been given, we are of the opinion this is on the higher side. Reason being a bank, we have taken all responsibility.
No, you say in this pair portion at page number 28,
My lord.
the complainant has not made any pair for awarding compensation for the deficiency of service.
No, mental stress and harassment 5 lakhs and 2 lakhs.
Harassment is there
Yes.
for deficiency of service.
But there's
Whether
no-
harassment and deficiency of service is interchangeable.
Maybe the National Commission has taken as a whole and given 10 lakhs rupees. This is
No,
what
if you have no authority in view of the observation made by you in made by the commission in paragraph number 16, then
authority.
how can you
authority
assess
in
that?
respect of only of gold, only on value of gold, nothing more than that. That is why I am indicating on only in respect of value of gold. As far as deficiency in service there, that's the court can opine.
Okay. Heard Mr. Soikia, learned counsel for the petitioner, and also heard Mr. Sahyawala, learned counsel for the respondent. Argument concluded, judgment reserved.
But we have also placed the RBI guideline.
Does it come subsequently, my lord? That has come subsequently, my lord, after these.
No, my lord. Before the order of National Commission was passed, it has come up. The lordship once I can give because
No, before the commission, state commission,
No.
the matter was first filed before the state commission, complaint was filed.
Lordship. State commission.
So at that time of filing of the complaint before the state commission, what was the position? Whether RBI guideline was available at that
my
point?
lord, there was no guidance.
No, guys.
That is
They
why
are-
this
they are-
Rajgupta
they-
case, in this
they are-
Rajgupta case, the courts directed the RBI, please
Then
formulate a guidance.
so the guidelines which were issued subsequently, can we take cognizance of the same?
I leave it to your lordship because what has happened in Rajgupta case.
Anyway, you file it to the court
Right,
master.
if your lordship is.
Submit it to the court master.
44.
May it please your lordship. Lordship, this is an statutory appeal filed by the appellants under section 173 of the Motor Vehicles Act, lordship. The appellants are the claimants of the disease. Impugn order starts from page 23, lordship.
Heard Mr. Bordolo, learned counsel for the appellant. This appeal under section 173 of the MB Act is directed against the judgment and award. Against the judgment
Judgment, Lordship.
24/4/2025 passed by the learned member Motor Accident Claim Tribunal, Biswanath Sarili, in MSC case number 11 of 2023, which is again B. It is to be noted here that by the impugn judgment dated so and so, the learned tribunal has dismissed the claim of the appellant. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugn judgment dated 24/4/2025. Admit, issue notice to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Registrar shall call for the record from the learned tribunal, list the matter after 4 weeks.
Lordship, can I submit one thing, Lordship? Judgment and order, Lordship. Page 32 is the order, Lordship. Page 32, Lordship.
This order is part of the judgment.
Lordship. Oblige, your Lordship.
My lord, one item, Lordship, item number 15, Lordship. It was showing as item number 14, Lordship. I was in some other code, Lordship. Now order has been passed, Lordship, whereby case is fixed next week. Lordship will fix the matter, let the order remain as it is, Lordship. Only
Okay,
thing I pray that interim order may be extended till the next day.
Later on, Mr.
Item 15.
Your
A
name?
Ganguly for the petitioner.
A. Ganguly. Entered appearance. Interim order, pass order shall contain.
I'm obliged, Lord. Oh, here is number order 41. Item number 17.
So your memo of appeal start from page number 1
Your Lordship.
till page number 20, right?
The substantial questions of law, Your Lordship would find it page 16.
Page 16.
Your Lordship.
Oh, according to you, which is the main substantial question of law here?
Lordship, basically there are two main grounds of challenge.
What are those?
One is whether the suit could have been filed by a sole proprietorship concern on its own name. Because as per CPC Order 30, Rule 10, there is a clear bar that a suit cannot be filed by a sole proprietorship in its own name, though it can be sued in the name of a sole proprietorship concern.
So where you have suggested that question?
Your Lordship, page 17.
What number?
Page 17, Your Lordship.
Point number?
S. Lordship, why this is important? If you're actually, I'll just take you through the cross examination of the PWs. Lordship, the only reasoning, if I may say, was given by the learned First Appellate Court that the suit was duly instituted was because in the cause title of the suit, the name of the plaintiff firm was given and it was shown as represented by Shri Rituparna Ray as proprietor. And that in the affidavit and verification also, the said legal person Rituparna Ray had signed. So merely on this basis, the court proceeded to hold that the suit is maintainable. But Your Lordship, if you peruse the cross-examination of, for instance, PW2, who is the brother of the plaintiff, in his PW2 he specifically states that I am partner with my brother in the said business. Also, Your Lordship, the PW1 in his plaint states the trade license of the firm, but then he does not exhibit the trade license of the firm. In the cross also suggestions are given to him that have you exhibited any document in support that you are the plaintiff of the firm? He answers in the negative.
No, here you tell me which provision bars the sole proprietor in filing a suit?
Your Lordship, Order 30, Rule 10.
The firm was registered in the name of the plaintiff.
There is no documentary proof available that was registered in the name of the proprietor. He just claims to be the proprietor of the firm, but there is no documentary evidence on record, Your Lordship. Even in the cross-examination suggestions are given to him, he denies that I have not filed any document to substantiate myself as proprietor of the firm. In the PW2, he says that I am a partner along with my brother in the same business. If I may just take you the relevant portion of the cross of PW2, Your Lordship. Your Lordship would find it
No,
at
Mr. Counsel, you say here, we can admit the appeal only on the substantial question of law. The question you have referred is a question of fact. This in the second appeal, we cannot go into the question of fact.
Your Lordship. The question of law is that whether a suit can be filed in the name of a sole proprietorship concern. That is the main substantial question of law by a person claiming to be a proprietor without there being any evidence or record to substantiate the same, Your Lordship. Your Lordship may give me some time on the next date. I'll satisfy Lordship, Your Lordship.
Okay. Pardon me, sir, your good name?
M. Shah.
Learned counsel for the appellant. This appeal under section 100 of the CPC. Read with order 41 rule 41 and 43 and 42 of the Code of Civil Procedure is directed against the judgment and award dated 11/9/2025 and decree dated 24/9/2025 passed by the learned civil judge, senior division, Bongaigaon.
So it will be Bongaigaon. Hailakandi is a typing mistake. After Bongaigaon, it is Bongaigaon. Civil Judge Senior Division, Bongaigaon.
In money appeal number 1 of 2023, arising out of judgment and decree, stroke order dated 4/8/2023 of the learned civil judge, junior division, Bongaigaon, in money suit number 5 of 2020. Full stop. It is to be noted here that by the impugned judgment dated 11/9/2025 and decree dated 24/9/2025, the learned first appellate court has dismissed the appeal and thereby affirmed the judgment and decree dated 4/8/2023 passed by the learned civil judge, junior division, Bongaigaon. List the matter on when?
Lordship, next week.
Okay.
Twenty.
28th of February
Obliged.
for further consideration of the substantial question of law. It also appears that some error crept in the cause title of the memo of appeal. The learned counsel for the appellant shall take necessary step for correction of the same before next date. Please
Obliged.
accordingly.
Number 43.
May it please your lordship. Lordship, this is the structural compensation matter that was fixed.
Yes.
But I have done for the record. In fact, but the compensation which is paid to the petitioner, it was wrongly paid to the private respondent. So ultimately, the private respondent, he in the affidavit is said that he is also entitled for some amount. So he has taken that amount to be his amount. That cannot be, otherwise the records are very clear. In the record itself, what I have seen, the undertaking given by him, he has asked for 1 month time, saying that you give me 1 month time, I'll return the amount. That record is here. So under these circumstances, the specific query of the lordship, that who will pay the amount? For the private respondent, he should return the amount, will pay the amount to the petitioner. That is his particular. The private respondent number 8. His tax number is 440, patta number is 217, and he's entitled for, I have taken the instruction over 4, he's entitled for 9 lakhs or something amount.
No, Mr. Nath, you tell me who acquired the land from him?
The district authority.
District authority, and it is whose duty to pay the compensation?
The NHA, they have given us the amount.
Yes.
The disbursing authority is the alia is the authority.
Yes.
They are to disburse.
So you have wrongly paid to another person.
But lordship,
You can recover it, or you may recover it, may not recover it. We are not concerned with that. You pay the compensation to the petitioner.
Ultimately, that is there. But kindly also appreciate that the amount is not with us, and it is admittedly it is with the private respondent. Since all the parties are before the lordship, petitioner is before the lordship, the authority and the private respondent is also here. The 55 lakhs which was calculated for the petitioner, wrongly it has gone to him. Plus, since the private respondent is before the lordship, he cannot be allowed to take the advantage when he has given an undertaking that he will return the amount. Long back he has given the undertaking. Now, my lord, while filing the affidavit, he has taken a plea. These are afterthoughts, my lord. In the affidavit I have seen, these are afterthoughts that I am also entitled for some amount. This amount has come, I have spent the amount. So this undertaking is there, my lord. Ultimately, this is the photo lordship will appreciate.
No, in the name of equity, we cannot decide the dispute between two brothers. Between the petitioner and the private respondent number 5.
In fact, they are not there.
Yes.
In fact, the petitioner has land in dock number 428, patta number 146, and dock number 426, patta number 143. Totally separate. Record I have seen, totally separate land. Only because the name resembles. Son of one is Probin Gora, son of Bhakti, the petitioner. We have acquired two plots of land from him under dock number 428 and 426. And the private respondent, he claims that I also in the record I have seen his land is dock number 440, patta 217. So that is why the problem arose. Ultimately,
No, that is there. I have seen it. I have seen it.
Lordship, be that may be, for the mistake on their part, the petitioner has been suffering since 2009. The money has not yet been received by him, and he's an aged person, Lordship. So.
Since all parties are before the lordship, my lord, it is not that the person we cannot identify or he is not available, he is not known. All before the lordship, my lord. Considering the undertaking, my lord, ultimately it's a public money. So suppose my lord, assume me. Lordship says that the DC has to pay the amount. Ultimately, it's a land acquisition compensation amount. The authority for whom the land has been acquired, money comes from them. And they are the disbursing authority. They don't have their own money.
Maybe, but
One person is enjoying the money, or not. One person who is before the lordship, he is enjoying the money without having any right.
no, Mr. Nath, you tell me, in the name of equity, can we direct him to pay the amount? Private respondent number 5?
But at least,
private respondent number 8.
At least he could say that this is not my undertaking. Undertaking is there, my lord.
Pardon?
Undertaking is there. His undertaking.
No, you tell me, can exercising the power under Article 226, this court can direct him to pay the amount to him?
Well, in fact, the parties are before the lordship. He is to return the money because it is wrongly counted. Well, if he has the defense projected by the private respondent today before this honorable court is that I am also entitled for some.
No, here we cannot adjudicate that matter.
So that plea he cannot take. That is what I am submitting. That plea he cannot take. He cannot adjust that somebody's amount has come. I am entitled for some amount, so that is why I have adjusted the amount. I will not return because knowing fully well, he said that give me 1 month time. If lordship says ignoring this undertaking, which is available in record and the other records, that amount has been wrongly done to him. If lordship directs the deputy commissioner and follow the respondent is
Why direction is necessary? Why direction from this court is necessary? Is it not your duty to recover the amount from him and to pay the same to the right person?
Steps have been taken.
Then-
FIR have been filed. Notice
Then-
to publish. And as per law of that, definitely that liberty we have. If today.
Why you could not attach his bank account?
I have seen letters were written to the bank authority also.
What happened thereafter?
later, the letters have been written, but they, after that, what happened, that I have not seen.
Hmm?
But if the private respondent is now today, let the lordship allows him to go without any order, ultimately he will get advantage which he doesn't deserve. That is also before your lordship, lordship will also see that.
Hmm.
And undeserved benefit he is enjoying. And everything is before your lordship now. So my humble submission is that, of course, lordship can see that also.
Hmm.
Petition is entitled, there is no doubt. Here I have seen that the amount with interest he has paid. That is another part. But at this stage, whatever amount is calculated, that lordship, the respondent is available here because ultimately the amount has gone to him.
No, Mr. Nath, you cannot push the responsibility to the respondent number 8.
One thing, lordship can definitely, lordship can say, because of whose fault the responsibility has to be fixed. That lordship may pass an direction to us because everything has happened in 2015. We are in 2026, the officers from whom we are taking instructions, they are relying on the record only because they don't have any personal knowledge. So because of whose fault, whether it is bona fide or whether it is in collision with something, fact pending lordship is to be fixed. That is definitely one of lordship may direct us.
Maybe, but that will not serve his purpose. Huh?
No, ultimately, let us find out because the respondent, private respondent, and the respondent authorities at that point of time.
Well, Lordship in Kala's Lordship in Kala's
Yes.
That has been seen. Otherwise, it was an incident, and there may be some other incidents also. But that is one aspect. But since lordship, everything is before lordship, that will also have to see.
When the respondent number 8 has given his undertaking,
It is on in my record in the month of December 2015, 29 December 2015.
then why you failed to act upon such undertaking given by the respondent number 8?
Subsequently, before this honorable court, I have seen the affidavit, he has changed his stand. Para 14, kindly see page 124 of the affidavit lesson number 8. He said that it is the returns placed not to be done. Why they have to put the amount in my account? If it has come to me, it is I take it to be my amount, my money.
100
124 para 14 it starts. Kindly come to the next page 125. I'm reading the paragraph. That with regard to the statement made in paragraph 16, the present respondent makes to state that the amount which has been paid to the present respondent are for the land and structure acquired by the respondent authorities and not due to wrongly deposit of amount as claimed by the petitioner, and as such, the claim made by the petitioner in the following paragraphs that it is an admitted position of facts that the respondent authorities for reasons based to known to them had deposited the amount of rupees 50 lakhs 21,954 of the petitioner in the account of the deponent, and the petitioner is entitled to get the said amount is not correct. He denied.
Okay, we will direct you to pay the amount to the petitioner, which he is legally entitled to. You arrange the fund, or you recover the amount from the respondent number 8.
I leave it to your lordship. I leave it to your lordship and report my submission, but that I'm hardly praised for your lordship that lordship can direct the respondent to repay the amount so that we can pay the petitioner. This is my submission, lordship, by record, kindly record. Otherwise, if the National Highways acquisition, they have no fund. The fund has been given by them. It has been utilized wrongly. So we pray that he should return and we will pay. That is our application.
Yes, respondent number 8.
Second, I would like to submit note. They file a FIR against the respondent. Which is numbered as CR case number 1708. That one of this case for them. This is the election. Election R3, 150 lordship.
Page 1.
150. 156. Lordship, silence in the relevant portion, let's the page 176 lordship. The last part lordship.
Page number?
Page number 176. The last part lordship.
Paragraph number?
That part, 8 line lordship from the bottom.
Yes.
Hence, in respect of this point of determination at one stage, I find that prosecution's right in respect to prove that the accused person was entrusted the money for with another person that accused was attended to. And on the other hand, prosecution had also failed to prove that accused person had made promise in writing to return the money and honestly failed to do so lawfully. And thereafter accused of lordship.
No. You have given the undertaking before this court. Where the undertaking was given?
Before the ADC.
ADC.
ADC line of issue.
Where is that undertaking?
Well, it is in record. It is in record. Well, can we just slip 2-3 sentences before that particular thing? Police did not seize the document. That is the reason. Just 3-4 sentences before. Police did not seize the document. And therefore, Honorable Court said that it is not proved. This number. Better to be ready for it. Ready to guess. Anyway.
You see, yeah, one undertaking was given to return the amount in a petition addressed to the additional deputy commissioner, Jorhat.
But in his affidavit in opposition, he denied his sale also. And the compensation is rightly paid to him as his land was acquired under that number 440, EP number 217 lordship, where one RCC building was there. And 4 homes were constructed by the respondent. And that was acquired by the government.
So, Mr. Nath, you see, after this undertaking, what step the additional deputy commissioner has taken for recovery of the amount? Here it is stated that the amount is in the account, in his account.
In the affidavit, just the next page of that particular undertaking is a letter to the bank authority that letter written to the bank authority. Just next page to that undertaking.
Then what action was taken by the bank authority?
That, I have not, that I did not get about that. But it was written, it is there, and ultimately in the affidavit filed by, we have also said, in para 6, that we have written to the bank to retain the entire amount of rebate for us. And we have also requested a circular officer if our resident. The affidavit filed by the ADC.
No, thereafter you have not pursued the matter.
But in fact, the FIR was filed. And
No.
to my affidavit, the matter is subjudice before the LTC and Gauhati. In the vigilance cell of before the vigilance cell also there is a complaint.
So you have no instruction as to what action was taken by the bank authority
But that
on the basis of this letter.
that I have not seen in the file. Only writing to the bank and the affidavit also he has said. And rather that I have not seen, in the files in this I think it is not available. So it should respond from the bank.
Is the bank or retainer being collected? Sign of sign, BKC. BKC. Standing council. So now, Mr. Nath, you cannot obtain any instruction in respect of this letter.
I can take a look.
You can.
I can take a look. What is the reply? What is the response from the bank? I can take a look. And I'm also in the record, a lot of office notes are there. I have yesterday at night I have tried to locate. Over from I'm told that the private respondent, he is supposed to get 9 lakhs or 8 lakhs rupees of compensation. So whatever amount he is claiming that I am entitled for this, I have kept. That's not correct. That instruction also is logic. Can it last me some time? I can take that. I'm not paying for time because yesterday I understood that I'll make some change. That is why I have not sought for time at the beginning. If logic kindly give me some time, the bank's response as well as the particular amount which is entitled, the respondent number is entitled. Both the instructions I can take. And I can apply the local code. it is a wrong, Lordship. Absolutely, Lordship will not allow the respondent number 8 to take advantage of the wrong. It is a wrong part of the decision, the color. That's correct. But at the same time, the respondent number 8 also cannot be allowed to have advantage of the wrong. Lordship will punish the authority. But at the same time, he cannot be given the.
No, we are not concerned with the punishment. We are concerned with the amount of
Yeah.
compensation which the petitioner is
petitioner.
entitled
That's-
to.
That's true. This is
Do you have any instruction in respect of the amount lying in the account of the respondent number?
Lordship, we don't have
No.
any instructions regarding the private respondents amount.
Lordship, done with today's time alone. I'll take up with the
2 days.
Okay.
Okay, let it be on Monday then.
Lordship would at least reflect, this is the 5th time they are seeking instructions. And it has been pending since a long time now. So Lordship would at least reflect that this would be the final tender.
I think Lordship may also appreciate, this is, I have seen in the file, this everything has happened in 2015. Petitioner has approached in 2024. For 9 years, they were also not there. They did not file a case.
No.
In any case.
Though
any
they
case,
have not approached this court, definitely they have approached the deputy commissioner Jorhat.
That's good.
Yes.
So there are developments. Instructions have come, records have come. These two information I'll take.
Hello.
Please number কিমান আছে যোনখন দেখাইছিলে মই পাছ কৰি
Heard, Mr.
I Bhuya, Lordship.
Learned counsel for the petitioner. Mr. C. Bora, learned standing counsel for the NSI DCL for the respondent number 2 and 3. Mr. D. Nutt, learned senior government advocate for the respondent number 5 and 6. Mr. Hendrik for respondent number 4. And Ms.
Sorry.
B. Soria, learned counsel for the respondent number 8. During the course of deliberation, Mr. D. Nath, learned senior government advocate, has produced the relevant file of the ADC before this court and pointed out that on 29/12/2015, the respondent number 8 has given an undertaking to the ADC Jorhat that within a period of 1 month he will return the amount that has been transferred to his account. And thereafter, on 24th of December 29. No, Mr. Nath also pointed out that on 24th of December 2015, the ADC Jorhat has written a letter to the branch manager, SBI Kotoki Pufuri branch Jorhat, in respect of requesting the branch manager to retain the entire amount of bank account number 1039 2320-665 in the name of Sri Praveen Bora until further order. Until further order. And also to intimate the ADC regarding balance amount in the bank account. Mr. Nath further submits that he has no instruction as to whether any response was received from the branch manager, SBI Kotoki Pokore branch or not. And he submits that he may be granted 2 days time to obtain instruction and also instruction in respect of the amount of compensation the respondent number 9. Respondent number 8 is entitled to in respect of the land acquired from him by the ADC Jurat. They are allowed to recessal list the matter on Monday. So,
18 lordship, Monday my senior is not available.
18.
Yes, Lord.
Okay, on Wednesday.
18th.
Recessal list the matter on Wednesday. So as to enable Mr. Nath to obtain necessary inspection. Record produced before the court be returned to Mr. Nath. And Mr. Nath shall retain the same till disposal of this petition. That's all.
Turning item 12 for admission.
May I please, Lordship?
Yes.
Petitioner has prepared a probate of an will. Subsequently, the case is registered as probate title suit. During the evidence stage, there are two petitioners, two plaintiffs. Only one plaintiff has adduced evidence as PW1. Thereafter, prayer was made for adducing evidence on affidavit. Subsequently, the prayer of the petitioner was rejected and he debarred from filing further PWs. On being aggrieved, this petition is filed. So evidence is now ready with the plaintiffs. If your Lordship kindly allow us to file the PW evidence, then only the plaintiff case will be succeeded. Otherwise, plaintiff will lost, irreparable loss and injury caused to the plaintiff petitioner, Lordship. Admittedly, he had sought for time repeatedly, but on last day, okay then.
In this case, the time was sought by the petitioner on the ground that Hiren Kakoti was hospitalized. He was seen.
No, he.
He was hospitalized. So which he could not come to the court on that particular day, which was fixed for PW. So far the Hiren Kakoti conference.
So only on one date he could not appear.
Earlier, Swami, you are not.
Earlier also.
Order, 20, page 25.
Earlier also time was
allowed. Conduct is very clear that they are very negligent towards the patient. Paragraph 4. Before receiving that on the previous day, petitioner was directed to file the evidence, if any file is without fail. The record also reveals that petitioner filed his evidence on 3/6/2022. And since then, he has been seeking adjournment of further evidence. It appears that the petitioner has been seeking adjournment casually on this ground. Today also the petitioner has undergoing treatment. And this Hiren Kakoti, so far Hiren Kakoti is concerned, Hiren Kakoti has already filed evidence. On the same ground that Hiren Kakoti could not come to the court, that is why evidence could not be filed on 23/11/23. That is absolutely irrelevant. Gauhati already filed PW1.
Some default on the part of advocate, maybe. Some default. on the
The
part of
documents which they have annexed, it is in respect of
Hiren Kapote.
Hiren Chandra Kapote.
Because
The first time they annexed it along with this application, in the revision petition. But of the record, here, the cost by imposing cost can be allowed of the record also. Otherwise, my objection will be recorded. Ultimately,
otherwise, petitioner will obtain irreparable loss and injury, seriously prejudiced. Because it is a probate case without attesting witness evidence, and in fact, petitioner plaintiff's evidence, case will be, result will be clear otherwise, lordship.
So whether the proceeding is stayed by this court?
Yes, it's state, it is state.
When?
It was stayed on the very first day. It is stayed on 1/3/2024.
Heard Mr. B. Fukun, learned counsel for the petitioner. And Mr. N. Sharma, learned counsel for the respondent. In this petition under Article 227 of the Constitution of India, the petitioner is challenged the order dated 23rd/11/2023 passed by the learned additional
District Judge number 3.
Additional District Judge number 3, Kamrup and
Metro.
Gauhati. It is to be noted here that by the impugned order dated so and so, the learned trial court has debarred the petitioner
To reduce further evidence.
from filing further evidence, further affidavit evidence.
Further evidence.
You have already filed affidavit there.
No, PW1 has already filed.
Okay. So what is the ground of why you could not file your affidavit?
Because of illness, he is in ill health.
Illness. Where is that the document?
Hiren draft is in respect of Hiren Chandra Kapote. But Hiren Chandra Kapote already filed PW1.
File.
Other petitioner was also in, but that time
Mr. B. Fukun, learned counsel for the petitioner submits that the petitioner has instituted a proceeding for granting probate of will executed by their father, late Kaliram Kakote, as the sole beneficiary and legatee of his will within time. And in the said petition, the respondent opposite party has filed a written statement. And in the said proceeding, one of the witness, namely Hiren Kakote, has filed his evidence in affidavit. But the petitioner could not file his evidence in affidavit on account of illness. For which the learned trial court by the impugned order dated so and so has debarred the petitioner from filing further evidence in affidavit and posted the case for cross-examination of PW. Mr. Fokon submits that unless the petitioner is allowed to file his evidence in affidavit, he will suffer serious prejudice and would not be able to establish the case. And he further submits that by imposing some amount of cost, the petitioner may be allowed to file the evidence in affidavit. The learned counsel for the respondent opposite party, however, vehemently opposed the petition. Then he submits that the petitioner could not assign any reasonable ground for failing to file the evidence in affidavit. And though some of the document has been produced in support of the illness, the same also relates to one Hirensanda Kakoti, who has already filed the evidence in affidavit. Under such circumstances, Mr. Sharma, learned counsel for the respondent, submits that the impugned order so passed by the learned trial court suffers from no infirmity or illegality requiring any interference of this court. Para, having heard the submission of learned counsel for both the parties, this court has carefully gone to the petition and the documents placed on the record and also files the order dated, impugned order dated 23rd/11/2023. It appears that in the said order, the learned trial court has observed that after filing evidence in affidavit on 3/6/2022, the petitioner has been seeking adjournment for further evidence. And adjournment for further evidence. Seeking adjournment on flimsy ground, casually on flimsy ground for further evidence. And on that day also, the petitioner has not produced any document in support of the fact that he has been undergoing treatment. And thereafter, it has debarred the petitioner from filing further evidence in affidavit and posted the case for cross-examination of PW. Well, the impugned order dated 23rd/11/2023 is examined in the light of given facts and circumstances on the record. This court finds that the impugned order suffers from no infirmity or illegality requiring any interference of this court. However, it appears that the proceeding of the case stands stayed by this court by order dated 1/3/2024, and on that day the case was pending for cross-examination of PW. Accordingly, considering the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this court is of the view that end of justice would be meted out if the petitioner is given one opportunity to file his evidence in affidavit. Accordingly, imposing a cost of rupees 5,000.
Some less amount. Some amount.
Which shall be paid before which shall be deposited before the learned trial court before next date. The impugned order. the petitioner is allowed to file his evidence in affidavit. Evidence in affidavit. On such evidence in affidavit being filed, the learned trial court shall take the same on record and proceed with the case in accordance with law. In terms of above this, CRPIO stands dispose of parties are directed to appear before the learned trial court on
Next day is 17 March.
17 March.
On that day itself, they will find their evidence without.
17 March. Mr. Sen, some information is necessary from State Bank of India, Kotokipara branch, Surat. Regarding one account, there was a letter from the ADC Surat to keep the amount of compensation deposited in that account pending. And in respect of that, one letter was also written. And what action was taken by the bank upon said letter? You obtain instruction and apprise this court on next date, Monday. Monday or no, Wednesday. Wednesday.
Lordship, can you see on 19th, 18th, there is some personal difficulty with senior counsel?
19.
19th.
But you inform the other council.
I have informed the other council. Lordship, it's okay. On the 18th only, I'll be there, Lordship.
Okay, copy. You give a copy to him.
Well, we need to take instruction only with that letter.
Yes. Yes.
Done on receipt of the letter. That is the instruction we need. We will take it.
Much obliged.
I think for hearing and all that, let us have a copy of the petition. So that's.
No, that letter, copy of the letter of ADC, he will furnish it to you. So since you are not we are not implementing you as party here, therefore, it is only request from the court.
I have obliged.
Much obliged, Lordship.
I think for hearing under the 45. 41. Number 45.
May I please, your lordship?
Lordship.
Yes.
For the time being, my lord, my senior will be appearing in this matter again.
Okay.
Number 24 orders. Number 20.
In this case, I'm for the responding. In this case, the counsel for the appellant has written a Kalatnama. And prior to that, the appellant died and he has not been substituted. So the appeal is awaited. Already awaited, Lordship.
None appeals for the appellant on
They have
top.
filed an IA for withdrawal of their name. This matter may be closed.
May it please your lordship. Lordship, in this case, my lord, we have filed on IA for withdrawing our Ukalatnama, my lord. But till date, we have not able to contact the petitioner, my lord. We have also sent our legal notice on notice, intimating that we are going to withdraw our local.
Heard, Mr.
U Khan.
U Khan, learned counsel for the learned counsel. for the appellant in this case number 1 of 2022. Mr. Khan, learned counsel, submits that this interlocutory application is preferred for according permission to withdraw the wakalatnama on behalf of the appellant in this case number 1 of 2022. So is it correct that the appellant suffered demise?
We came to know that, my lord.
You came
Yes.
to know.
On 17/8/2024. More than 1 year ago.
And you tried to contract the legal heirs,
Yes, my lord.
but you have received no response.
No response, ma'am.
Mr. Khan submits that he heard that the appellant of interest case number 1 of 2022 suffered demise, and though he has sent he had tried to contract the legal representative of the appellant and also send notice to them, yet he failed to make any contract with them. And under such circumstances, this interlocutory application is preferred for according him permission to withdraw the wakalatnama. Taking note of the submission of learned counsel. No, taking note of the submission of Mr. Khan, this interlocutory application stands allowed, permitting him to withdraw his wakalatnama from the interest case number 1 of 2022. But now we have the registry has to send notice to the party.
The matter of notice has been sent by the party. Matter will close if they come, they will file the application for setting aside event. They will file fresh application. If sometime they feel that it is necessary. Otherwise, also because it has been a long time since 2024, the person dies, they should plus they have to come. The hurting of the appellant's counsel.
Heard Mr. Khan, learned counsel for the appellant, Mr. Sharma for the respondent. Mr. Khan submits that he has already filed an interlocutory application for allowing to withdraw the wakalatnama, and the same has been allowed. And he further submits that as per his information, the appellant suffered demise
on
17/8/2024, and he tried to contract the legal representative of the appellant, but he failed to do so. On the other hand, Mr. Sharma, learned counsel for the respondent, submits that this matter may be closed as the legal representative of the appellant has failed to take any step. Has failed to enter appearance in spite of the notice issued by the counsel for the appellant. Accordingly, taking note of the submission of learned counsel for both the parties, this case number 1 of 2022 stands closed.
Item 21.
Registrar will return the trial court record.
May I please, your lordship? Lordship, on the last day, the honorable court called the trial record from trial court, and which has been already been received. So the matter may be listed for admission hearing.
Heard, Miss?
Didas.
Learned counsel for the petitioner, and Mr.
N.H. Borby.
N.S. Barbonia, learned counsel for the respondent. The learned counsel for the petitioner submits that trial court record has already been received and the matter is ready for hearing. Accordingly, it is provided that registrar lists the matter for hearing. Admission hearing. To the fixed date.
After 4 weeks,
After 4 weeks.
April, first week of April. Yes.
Item 22.
Looks like the appeal has been admitted. This is for stay of the proceeding, the trial court.
Appeal abated.
No, it has been admitted, Your
Oh,
Honor.
admitted. Okay.
This matter, I am waiting for the respondent. The
Hmm.
trial court report is called for, and perhaps it has come. So otherwise ready for hearing. Maybe posted for admission hearings. After 2 weeks now. Any hearing dates.
So all the respondents are before this court?
Sole respondent.
Sole respondent.
Sole respondent.
Okay. Heard Mr. D.K. Bhattacharya, learned counsel
No.
for the,
R. Sharma, Your Honor.
oh, R. Sharma, sorry. R. Sharma for the petitioner. No, for the appellant. And Mr.
And now.
M. Nath, N. Nath, learned counsel for the respondent. Office note dated 23rd/8/2023 indicates that the trial court record has already been received. In that view of the matter, it is provided that recusal is the matter for hearing after
2 weeks,
after 2 weeks. After 2 weeks.
That may be fixed, Your Lordship.
on a hearing day, man. On a hearing day.
Correct.
Wednesday, Thursday, any. 17 March.
And in the meantime, they may not take any coercive action, Your Lordship. At least
Pardon?
until disposal of this matter, Your Lordship, they may not take any coercive action.
No, no, unless
Application.
there is an application to that effect, we cannot pass such order.
Last came on
That is-
May 2000.
The IA is for stay of the.
We are on
proceeding.
26.
IA is for. IA 1081.
That matter will be handled. Last occasion came 2023.
Yes.
No dates taken by this appellant for listing of this matter. There is no urgency. There is no urgency. Last came May 2023.
Hmm.
We approached the registry, that's why it has come.
Hmm.
We approached the registry.
They've so taken at the appropriate time, Your Lordship. That is why they have appeared, Your Lordship. And
Pardon?
it has been pending for 2.5 years, Your Lordship, almost.
No, you have not pressed the IA. Now, what is the urgency?
Because Your Lordship, that hasn't come up before Your Lordships. That is why that was not pressed. It was expected that.
No,
it would
no,
come
whether you have
in a
mentioned the
normal
matter
course, Your
before
Lordship.
any court?
Lordship,
Did you mention the matter?
it is a manifest, Your Lordship, a decree has been passed for payment of around 34 lakhs odds, Your Lordship. Now, because they have come, Your Lordship, they might take some course of action or they might go for
You see,
execution. That's why, Your
Mr.
Lordship.
Sharma, to pass such an order, you have to satisfy 3 conditions that have been mentioned in Order 41, Rule 5, Sub-Rule 3. And further, you have to furnish security of the amount.
Lordship,
Are you ready?
Lordship, I have to take instruction for security, Your Lordship. But I am a housewife, Your Lordship. I don't have my own income. That is why, as a private party, Your Lordship, private individual, I cannot afford to give securities of a high amount, Your Lordship.
Do you obtain instruction? On next that we will consider.
Any day,
Lordship,
even day, next week, I'm ready. But otherwise, there is a precondition of deposit, the money degree. Unless this tree is egregiously bad, then they have to deposit. That's the mandate.
Heard Mr. Arson, learned counsel for the applicant, and also heard Mr. Nath, learned counsel for the respondent. Mr. Sharma submits that he may be granted some time to obtain instruction in respect of furnishing of security as required under order 41 rule 5. 41 1 sub rule 5 rule 1. For granting stay. Where allowed, recess is the matter along with the RFN number 19 of 2023 on 10th of March.
Not on 10th, Your Lordship. Not on 10th. 12th. 10th, I may not be available.
12 marks, Judge, yeah. 23.
May I please, Your Lordship? My lord, may I kindly see office note dated 3/2/2026, my lord.
In respect of other respondents,
Other respondents, my lord, as per office note dated, my lord, 22/8/23, my lord. 22/8/2023, my lord. Respondent
so
number,
service completed in respect of other respondents.
not sure, my lord, because as per this office 2023, your lordship, the respondent number 7, it was issued by learned court below. 8 also issued by learned court below. But whether it is complete or not, there that has to be indicated by the registry, I think, my lord. 6, my lord, complete as per office note dated 31/7/2025, my lord.
Heard Miss SSZia, learned
lord.
counsel for the appellant. Miss Soikia for respondent number
1 to 3, Lord.
1 2 3. And Mr. Singh for
Respondent 4.
respondent number
4.
respondent number 4. Respondent number 4. Ms. Zia, referring to the office note dated 31/7/2026, submits that service in respect of respondent number 6 stands completed. But it is not sure from the note of the registry whether service in respect of rest of the respondents is completed or not. In view of above, it is provided that registrar shall put up an up-to-date office note indicating whether service in respect of all the respondents that's completed or not. List the matter after a week.
Item 24.
Your Lordship may kindly see the office note dated 21/1/26.
Office note dated
22/1/26. Service on respondent 3 hasn't been completed yet.
you have filed.
Nine for respondent number 1 and 2.
How many respondents are here?
3 respondents.
Three.
Three.
Service, that means service completed.
Service is done.
Whether the record was called for?
Actually, till this day, service was not completed. He appeared today to record. Record was actually called for in one order.
কবে? Call for records on the office number. নোট বিলাক নাথাকে এতিয়া ৰেকৰ্ডো নাথাকে না ৰেকৰ্ডৰ কথা নাথাকে নটিছৰ
Over there.
Report not received 11/24. Copies of.
So registering will issue reminder to the trial court for transmitting the record. Heard, Mr.
KM Kalita.
Learned counsel for the appellant, Mr.
A. Sarma.
Learned counsel for the respondent number 1 and 2, Mr. Learned counsel for the respondent number 3. Though service in respect of all the respondents since completed, the note of the registry is not clear as to whether the record has been received or not from the learned trial court. In that view of the matter, it is provided that registry shall put up an up-to-date office note in respect of the receipt of record from the learned trial court, and in the event of the record, no, in the event of non-receipt of the report or record, registry shall issue urgent reminder to the trial court for transmitting the record and list the matter after 2 weeks. After 2 weeks. matter are they covering?
May I plead your lordship?
Yes.
Lordship, steps has already been taken 1 week time may be granted as service report is still awaited.
Heard, Miss?
Am thus appearing on behalf of SK Medhi.
Learned counsel appearing on behalf of Mr. S. Kennedy, learned counsel for the appellate. The learned counsel submits that step has already been taken and she tries for listing the matter after a week, awaiting service report upon the respondents. They are allowed to list the matter after a week, awaiting service report upon the respondents.
26.
Obliged. এখন কার? My lordship, in this transfer petition, I am praying for transfer of the divorce proceedings from Udalguri District Court to the Court of Principal Judge Family Court, Borpeta. And on the last date of hearing, the counsel for the respondent sought some time to seek instruction whether to concede to my prayer for transfer.
Yes. Your lordship, we have no problem. We have no objection to that.
Okay. Then we will pass the order.
Yeah.
Heard, Miss?
A Deka.
Learned counsel for the petitioner. And also heard, Mr.
I am appearing on behalf of P. Upadhyay. I am appearing on behalf of P. Upadhyay.
Learned counsel appearing on behalf of Mr.
P. Upadhyay.
P. Upadhyay, learned conducting counsel for the respondent. This application under order 24 of the Code of Civil Procedure is preferred by the applicant for transfer of title suit within bracket D, number 18 of 2025, from the Court of Learned District Judge Udalguri to the Court of Learned Principal Judge Family Court at Borpeta. The learned counsel for the petitioner submits that the petitioner is the wife of respondent number 1. Is the wife of respondent who had instituted title suit within bracket D, case number 18 of 2025 before the Court of Learned District Judge Udalguri. Learned District Judge at Udalguri for dissolution of the marriage between the petitioner and the respondent. You have appeared in the title suit?
My lordship,
You have
there is a
appeared?
stay order of the divorce proceedings. There is a stay order, my lordship.
When it was passed?
Once.
So what is the ground for transfer?
My lordship, she is residing with her parents in Borpeta and she doesn't have independent income of her own. And further, there are two already cases which are ongoing in Borpeta court before the learned CJM and also before the family court principal judge. One for maintenance and one for domestic violence, in which the respondent is also taking part. I mean, the ongoing cases, there are two ongoing cases in Borpeta court.
The learned counsel for the petitioner further submits that the petitioner is residing at Borpeta
After her separation from her husband in the year 2023 itself.
Since the year 2023. And two other proceedings, one under Section 12 of the Protection of Women from Domestic Violence Act 2005 and the other under Section 125 of the Code of Criminal Procedure is pending before the family court before the CJM Borpeta. And next is family court at Borpeta. And that she has no independent income to contest the title suit D, case number 18 of 2025 before the Court of Learned District Judge at Udalguri. And under such circumstances, she submits that this petition may be allowed by transferring the title suit D, case number 18 of 2025 from the Court of Learned District Judge Udalguri to the learned principal judge, to the court of learned principal judge, family court at Barpeta. The learned counsel for the petitioner submits that the learned counsel for the respondent was directed by order dated 28/1/2026 to obtain instruction as to whether the respondent is inclined to concede to the pair of the petitioner regarding transfer of the title suit D number 18 of 2025 from the Court of Learned District Judge Udalguri to the Family Court at Barpeta, and the learned counsel for the respondent has to apprise this court about the instruction he has received from the respondent. The learned counsel for the respondent today on instruction apprises court that the respondent herein has no objection in the event of transferring the title suit number so and so pending before the Court of Learned Principals, learned District Judge Udalguri to the Court of Learned Principal Judge Family Court at Barpeta. Accordingly, taking note of the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this application stands allowed. Title suit number D 18 of 2025 pending before the Court of Learned District Judge Udalguri stands transferred to the Court of Learned Principal Judge Family Court at Barpeta. The petitioner shall obtain a certified copy of this order and place the same before the Learned District Judge Udalguri. And on such order being received by the Learned District Judge Udalguri, he shall transmit the record to the Court of Learned Principal Judge Family Court at Barpeta forthwith. In terms of above this, application stands disposed of.
Obliged.
May I please? My lord, a petitioner before your lordship is a wife, my lord. The husband has filed, my lord, the divorce petition before my lord Principal Judge Kamrup Metro. And petitioner, my lord, seeking transfer. In the meantime, my lord, what happened? Both the my lord husband and wife are interested to settle their dispute, my lord. My lord, may I pray for a my lord, director, my lord, matter may be referred to the mediation matter. Entire matter, my lord, some cases are pending in Nolbari, 1 or 2 cases are pending in Kamrup Metro. But all the cases, my lord, they are amicably will settle, my lord. My lord, both the parties are interested. That's why, my lord, my humble prayer before you, lordship. Matter may be.
No, if both the parties are interested to settle their dispute,
Yes.
Why mediation is necessary?
My lord, in fact, my lord, if the my lord matter is referred to the mediation, my lord, both the party will appear, my lord, there, my lord, some my lord, mutual talks will be, my lord, initiated, my lord. That's why, my lord.
No, if both the parties are agreed, then why should we refer the matter to the mediation, to the mediator? You settle the dispute and file an application before this court.
Lord, I think, my lord, I think, my lord, it will be better, my lord, if mediation herein, my lord, High Court Mediation Center, my lord.
Is good, and that is why if the he wants to tell that on a lot may refer that this to the mediation center, then the entire.
So you are also agreeable to his submission?
My lord.
Okay. Heard, Mr.
A. Manna.
A. Manna, learned counsel for the petitioner, and Mr.
A.K. Bodale.
A.K. Bordoloi, learned counsel for the respondent. It is submitted at the bar that the parties to this proceeding are husband and wife, and they are agreeable to settle the disputes amicably. And as such, the matter may be referred to the Mediation Center, Guwahati High Court to set out the terms and conditions of the settlement. Accordingly, taking note of the submission of learned counsel for both the parties, the matter is then referred to the Guwahati High Court Mediation Center. Rest shall list the matter before the mediator. Put up the matter before the mediator. Suggested date?
My lord, after 10 days, my lord, date may be fixed, my lord, after 10 days.
27.
27 is difficult.
Wednesday.
26.
26.
On which both the parties shall appear before the mediator. After the mediation, the mediator shall file a report before this court. List after
26.
after 4 weeks first. Okay?
4 weeks.
No, like
6 weeks.
6 weeks. After 6 months.
My lord, till then, my lord, the interim order will be continued. My lord.
Okay. Interim order parcel shall continue.
Obliged, my lord. I love.
Item 28.
Lordship, as per office note dated 9/2, the answer of notice upon respondent number 2 and 4 have returned with a remark that insufficient address, Lordship. So some time may be given to obtain a proper address, Lordship. And with regard to respondent number 1 and 3, 1 and 3, 2, the service report is still awaited, Lordship.
Mr. Nayak, you are for?
I'm preparing for respondent number 1. I'm the degree of the matter. My only concern is that one frame order is continuing and the proceeding is pending at the stage of execution. That is my concern. Respondent number 1 is the old lady Lordship and she is fighting this case in 2008. So that is my only concern. Lordship will take note of that and definitely it will have to complete the stage clause.
Heard Mr. Singh, learned counsel for the appellant. Mr. Nayak for the respondent number 1. Mr. Singh submits that. Mr. Singh, referring to the office note dated 9/2/2026, submits that. State upon respondent number 2 and 4. Returned with a report insufficient address, RTS. And as such, he pressed for granting him some time to obtain instruction in respect of the address of the respondent number 2 and 4. Office note dated 9/2/2026 also indicates that AD card in respect of neither AD card nor unserved notice in respect of service of notice upon respondent number 3, 1 and 3, 2 received by the registry. In that view of the matter, it is provided that registry shall list the matter after
4 weeks, Lordship.
No, Lordship, 4 weeks will be too long, Lordship. Let them file an affidavit if they are not unable to find the address, Lordship. It is possible to be able to take a decision. Otherwise, this will keep lingering, Lordship.
No. Since the step returned with a report insufficient address, he has to obtain instruction in respect of the address.
From the petitioner.
From the petitioner, from the appellant.
Lordship. Lordship, one more order, Lordship may pass, Lordship. So perhaps the tax year of TS 73/2008. That is not yet.
Not received, Lordship.
And secondly, Lordship, one more RSA there, Lordship, 256/2015. That
Between
relates
the
to-
same party.
Yes, that relates to same list, Lordship. It was earlier, before this honorable court, one order was passed.
That was disposed of?
That is disposed of. Lordship, that order is necessary, Lordship, because some questions of law has been raised, Lordship. My only submission will be in that RSA, Lordship, entire matter was disposed of, specifically directing the first appellate court to dispose of the issue or adjudicate the issue in certain manner, lordship. That will be the only question of law, lordship, whether while adjudicating the matter by the first appellate authority, this order was followed or not. That is the only question of law. So in
No,
my understanding, lordship,
Mr.
that-
Nayok, you see, the substantial question of law has already been framed here.
that is as has been, raised by the petitioner, lordship, appellant, lordship. Or that is just, quoted from the petition, lordship. Even issuing those questions, lordship, nobody from the other side has been heard also. So that will be
No,
my-
what is the scope for the court to know the about pendency of the earlier RSA, about the
that is
disposal of
pending,
earlier?
lordship. That has been disposed of.
Is it mentioned in the memo of appeal?
No, no.
Yes, Lordship, it has been mentioned.
It is copy is not, yeah. Copy to next part.
Okay, later on we will see. At the time of hearing, if necessary, we will formulate any other substantial
Lordship,
question of
in that situation, lordship will keep this open, lordship, because this is a very important direction, lordship. And ultimately, by following this as well, only lordship, the first appellate court
No, no.
disposed of the issue.
Now there is no scope of making such observation. However, we will consider it at the time of hearing.
Lordship. Only the LCR of TS 73/2008, that is mentioned there in the office note.
And what is the number of the other LCR?
TS 73
of 2008, TS.
Okay. Office note dated 9/2/2026 also indicates that though LCR of PA case number TA number 12 of 2012 has been received, yet the LCR of TS number 73 of 2008 has not yet been received. Accordingly, it is provided that registrar shall issue reminder to the learned trial court for transmitting the record of TS number 73 of 2008. Mr. Nayok, learned counsel for the respondent number 1 also submits that earlier one RSA, being RSA number 256 of 2015 was filed. No, it was filed by the same appellant,
No, Lordship, by the respondent number 1.
by the respondent number 1. And the same has been disposed of by order dated, judgment and order dated
This is 05/03/2019.
05/03/2019. And the record of said RSA will be required at the time of hearing of the present appeal. And as such, he submits that the registry may be directed to take the RSA number so and so with the present record. Where allowed, registry shall do the needful in this regard and list the matter after 4 weeks.
He's only
No,
taking the-
now, Mr. Nayok, you see, he cannot take step unless he received the instruction from the appellant in respect of the address of 2 and 4. So we'll fix a very short date. In the meantime, he will obtain instruction and apprise this court, and thereafter he has to take step upon those 2 and
Lordship,
4.
I leave it to your lordship, but my suggestion will be, let him take instruction within 2 weeks. And in the next 2 weeks, lordship, let him take steps, lordship.
Okay, after 2 weeks.
Can it be 3 weeks, Lordship?
No.
2 weeks.
Only for instruction. We'll grant you separate time for taking step.
Lordship. Okay.
Lordship, in the IA, interim may be extended, Lordship.
Okay, interim order passed in the IS shall continue.
Obliged, Lordship.
In this case, today we have filed a case with also.
My lord, we have some urgency, so a short date may be kindly be fixed, my lord. Because the issue is very simple. The land grabbing case filed by the petitioner has been dismissed, citing the reason that amount of land is very less. It is 4 kotha 10 lesa, about 1 bigha. But that doesn't come under the purview of the Land Grabbing Act. That is the issue, my lord. If your lordship sees the page 62. So that is the issue. So I pray that a short date may be fixed, my lord.
Okay. Heard Mr. Bora, learned counsel for the petitioner. and Mr. Hussain for the respondent. Mr. Hussain submits that he has filed the affidavit. No, filed the objection today, and it is not placed on record. And he pressed for listing the matter on some other date. We are allowed to list the matter after a week
Yes, my lord.
and closing the objection filed by the learned counsel for the respondent.
Oblige. Kindly a date may be given, my lord.
25th.
Yes, my lord. Oblige, my lord.
Number 30.
May I please, Your Lordship, Lordship, this is a petition for review of an order dated 6/8/25 passed by Your Lordship. If I may just indicate the facts of the case. Lordship, suit was filed by us, seeking right title and interest, in which the father of the petitioner, of the respondent, was a defendant. During the proceedings, the father expired and he was substituted by his sons. We are not aware that there was a daughter as well, but the sons were there. Now, after entering appearance, Lordship, they did not contest the suit. As such, there was a decree in my favor, Lordship. And when I went ahead for execution of the decree, at that point of time, the daughter comes in and files a petition, which gets rejected. Thereafter, an application under Order 21, Rule 97/99/101 is filed, which is allowed. Now, prior to that, upon rejection of her petition for getting impleaded as a defendant, she filed a misappeal. And the misappeal was also rejected on the ground that she could not come out with the relationship with her father. Therefore, it was rejected. Now, again on application under Order 21, Rule 97, 99, and 101 is filed, which is allowed, and the respondent herein is allowed to give her evidence. Challenging that, CRP IO was filed for this honorable court, and the same was rejected by this honorable court by order dated Lordship 6/8/25, holding that any person under that proviso of the CPC would also include any stranger or any other person. What I am on, my lord, is if your lordship will kindly take Order 21, Rule 97.
No, that's all right, but very recently, about 3-4 days back, Supreme Court has referred the matter to a larger bench.
That I am not aware, but the decision that your lordship had referred, I have got later decisions than that. But if it is referred to a larger bench, then till it is decided,
Very recently,
till that decision is rendered,
or 2 or 3 days back, I have read it.
but till a decision is rendered in a larger bench, the decision of the earlier bench will prevail. That is what I am on. Now, for a moment, if your lordship will just have a look at Order 21, Rule 97 and 99. No, I'm just making it clear, lordship. The petition filed by my friend's client was under Order 21, Rule 97, 99, and 101. Now, when can a petition under 97 be maintained? Where the holder of a decree for possession of immovable property
or the purchaser of any such property sold in execution of a decree is resisted or obstructed by any person obtaining possession of the property, he may make an application to the court complaining of such resistance or obstruction. Now, your lordship will see the opening part. A petition can be maintained only if it is filed by the holder of a decree. It is not by anyone else.
No, no, Mr. Chaudhary,
Lordship.
this court has relied upon a decision of the Supreme
Yes,
Court.
yes. That has been further clarified by later decisions, which I would like to place before your lordship. If your lordship would allow me or.
No, no, yes, yes.
Ah.
Why not?
Yes. Your lordship had, if I may take your lordship to page 130 of my lordship petition.
Yes.
Lordship had relied upon Brahmadev Chaudhary versus Rishikesh Prasad Jaiswal. That was a case of 1997. If I may just read very slowly, lordship, for on the undisputed facts on this record, it has therefore to be held that because of resistance or obstruction offered by the appellant, amongst others, on 28/4/91, the application moved by the respondent decree holder. Lordship will mark the words respondent decree holder. On 6/5/91 was necessarily to be one falling within the scope and ambit of Order 21 Rule 97. It is pertinent to note that the resistance and or obstruction to possession of immovable property as contemplated by Order 21 Rule 97 CPC could have been offered by any person. The words any person as contemplated by Order 21 Rule 97 Sub-Rule 1 are comprehensive enough to include, apart from the judgment debtor, anyone claiming through him, even persons claiming independently and who would therefore be total strangers to a decree. Now, if your lordship will see, here is a case, it's just the opposite. Here I am the decree holder. The opposite party is obstructing.
No, no, you see the wording here?
Yes,
Any
yes.
person.
Any person. Now, that has been clarified in a later decision. So that was.
What is that judgment?
I could not make copy, lordship, but if I may, that has been clarified in Silver Line Forum. Lordship, today I'm a bit handicapped. I have not taken.
You have the copy of that decision?
I will give it to him, or lordship, if it can be in the next week, lordship.
Next week. Okay.
I'll be prepared.
And before that, your lordship, a preliminary objection I need to place before this honorable court. If your lordship goes through the readings of the thing, of the review application, it is clearly an appeal disguised as a review, your lordship. My learned colleague is saying that there is a amendment, sorry, the better judgments of clarification, but this fact, because error apparent is not evident. If your lordship sees the grounds taken, your lordship's order was there. Now, it is as if this review is assailing that order as an appeal, your lordship.
I will just point out, lordship, I appreciate what my learned senior is telling, submitting. Now, I have a judgment in my possession, in fact, a case I have appeared, where a review is permissible on a point if there is a subsequent decision of the Supreme Court on the issue and that was not placed before the honorable court at the time of hearing. That is a good ground for review. I have done a case, lordship. I'll place it. And in fact, that decision has been, lordship, taken crux of the decision has been taken from a decision of the Orissa High Court, wherein Justice Amitava Roy was sitting judge. I'll place that decision also, Lordship. Let it be in the next week, Lordship.
Pleadings,
I need not.
There
I
is
need
no
not.
pleadings that there is a subsequent, the pleadings clearly shows the ground. Is, if your lordship sees, it is a ground as if there is, as art in law, both in facts and law, as if it is an appeal that has been filed before this honorable court.
The pleadings, Lordship, the
Okay,
pleadings.
at the time of hearing, we consider the same.
And appeal are basically the same as per the CPC.
Okay,
Lordship.
let it be on next Thursday.
That is fine with me. 19?
Mr. Biswas?
Yes, yes, Lordship. Yes, Lordship. Yes, Lordship.
Okay. As agreed by learned advocates of both the parties, Registrar shall list the matter on next Thursday,
19th.
on which an endeavor will be made to finally hear and dispose of this petition.
In the meantime, Lordship, if he wants to file any preliminary objection or what.
No, I don't think he will file any objection.
He will.
If required, I will make my oral submissions. If required, I can.
Yes, yes.
Either of those. Item 32.
Yes,
Not file objection, Lordship.
you will not file any objections.
But Lordship, oral objection may be recorded.
Not today, but this matter is listed under the column order.
Yes, Lordship.
Oh, why this listed in the order column?
Your main is the filing number as I just want to check on
So there is delay of only 11 days.
Yes, Lordship. But the petition may be disposed of as part the merits, Lordship.
So what is the ground for which you could not file the appeal within time?
Your Lordship, respondent has paid for time and they have not filed the reply.
No. She is not going to file any objection. So now you tell me on what ground you could not file the appeal within time? What is the reason?
Your Lordship, my senior is on legs.
Who is your senior?
H. Gupta.
Are you to allow me? My lord, there was an IA, my lord, in the last occasion. In the IA, they have paid for time to file objection.
No, now they are not going to file any
In
objection.
that case, my lord, the condemnation will be allowed. Lord.
No, I am asking what is the ground?
My lord. No, in fact, I have misplaced my file, my lord, today.
You have misplaced
My
your
lord.
file.
My lord.
What to do then?
What can it be? No, Lord, actually, IA file actually, my lord. I can. The ground is at page 2, my lord. There is a delay of, my lord, 11 days only, my lord.
That is all right. You have mentioned in the cause title of the petition.
Yes.
But
my lord.
where is the ground?
Paragraph 2, my lord.
Is it a justifiable ground?
My lord,
Hmm,
11 days only.
Maybe.
My lord,
You have to explain even a single day
my
also.
lord, that is there.
Then
Not here, in fact, my lord, in the government department, my lord, they seek legal opinion in and obtaining certificate
Maybe.
if their channels, my lord. Especially in railways, my lord, there are more hierarchies, my lord. So
on that ground, you cannot seek condonation. That there are several hierarchies in the government
My lord.
department.
my lord,
Law is
latent-
applicable to
my lord,
all the litigants, be it private litigants or
No.
the government litigants
that is
or government department.
that is there.
So we cannot grant you special privilege being the government department.
My lord.
Heard Mr. Gupta, learned counsel for the applicant, and Miss R. Kaur, learned counsel for the respondent. This interlocutory application under Section 5 of the Limitation Act is preferred by the applicant, NF Railway, represented by the divisional manager Tinsukia and the state officer, NF Railway Tinsukia, for condonation of delay of 11 days and preferring connected appeal against the in preferring connected civil revision petition against a judgment and order dated 9/2/2024, passed in Miss Appeal number 14 of 2023 by the learned additional session judge number 2, FTC Tinsukia. Mr. Gupta, learned counsel for the applicant, referring to paragraph number 2 of the application, submits that after obtaining certified copies of the impugned judgment and order, the applicants have made internal communication with the department and subsequently legal opinion has been received from the Central Government Council to approach this court by filing civil revision petition, and in the process delay of 11 days occur, and the same is not intentional and rather it is circumstantial, and under such circumstances Mr. Gupta has contended to allow this application. The learned counsel for the respondent, however, opposed the application. According to the learned counsel for the respondent, opposite party, the delay has not been sufficiently explained. And under such circumstances, he has contended to dismiss this application. Having heard the submission of learned counsel of both the parties, this court has carefully gone to the application and the grounds mentioned therein. And it appears that the impugned judgment and order was passed on 9/2/2024, and the revision petition was preferred on 3/6/2024, and there is delay of 11 days. In view of the explanation so forthcoming for the delay, and also taking note of the submission of learned counsel for both the parties, this court is of the view that the delay of 11 days in preparing the connected civil revision petition is sufficiently explained, and accordingly, the delay of 11 days in preferring civil revision petition stands condoned. In terms of above, this IA stands disposed of. In view of the order passed in the IA, the registrar shall register the CRP and list the same before this court as early as practicable, as soon as practicable. This is very welcome, right? Next time, filing number or something. Oh, that's filing number. Survey number at all. Okay, no.
45.
May it please your lordship. This is an appeal by the defendant, lordship, against a common judgment, lordship. Already I have filed another regular second appeal that has already been admitted and stay granted by the court, lordship. I am the defendant and suit of the plaintiff was decreed by both the courts below and counterclaim was rejected by the court below, lordship. Challenging that common judgment, I have preferred one regular second appeal.
Madam, today it may not be possible to
Lordship.
complete hearing in this matter. Let it be
Lordship,
on
already,
next Tuesday,
Lordship, already another second appeal admitted
maybe.
against the
We have
decreeing
to
of the
see the matter, see the judgments.
lordship.
Some other matters are also there. We'll hear it on next Tuesday or Thursday.
17. Can it be on 16 or 18, lordship? Order 41 hearing on motion day also it can be taken up, lordship.
Monday or Wednesday or Friday.
Yes, lordship, any day. Hearing under order 41 may be listed on motion day, lordship. 18, lordship.
18.
Obliged, lordship.
Recess list this matter on 18.
Item 33.
For further consideration.
My lord, this case has become infructuous. Actually, the order which was challenged under challenge, my lord, actually we challenged the order allowing the defendant to file WS beyond the period of 90 days. Now, my lord, in trial court, their WS has been closed, my lord. So virtually this become infructuous.
Okay. Heard Mr. S. Das, learned counsel for the petitioner. Mr. Das submits that this matter become infructuous and as such, the same may be closed. Accordingly, this CRP IO number so and so stands closed.
That's all.
34.
May it please your lordship, my lord, this interlocutory application number 2974/25 was filed to restore the CRP IO 16 of 2025, my lord. Because your lordship was pleased to give liberty to the petitioner to withdraw the CRP IO number 16 of 2025, with a liberty to file any application before the appropriate authority, before the appropriate court, my lord. Thereafter, my lord, what happened? This petitioner have found that there is no such provision because the suit was pending. There was no decree passed in the suit. Therefore, the petition which was filed under 227 of the Constitution of India is appropriate, and your lordship may interfere with the impugn order passed by the learned civil judge number 2 by this is, my lord, fact this my lord, it's an ex parte order. To vacate the ex parte order, the petitioner filed one petition under Order 9 Rule 7. So against that order, against the rejection of our order of that petition, whether any CRP IO under 227 lies or not. Now, lordship, on the last occasion, your lordship was has put a question whether this court has the power to restore one petition which was, my lord, withdrawn with a liberty to file. On that count, my lord, Section 151 of the CPC lordship, your lordship has the inherent power to restore the CRP. And in this regard, my lord, one Supreme Court decision also there, my lord, where one suit was withdrawn and thereafter, an Honorable Supreme Court thereafter, my lord, has given the liberty, because 151 has the power of any court, my lord. Your lordship has the power to restore the CRP IO, my lord. May I give the citation, my lord?
Yes.
That was
No objection, my lord. My submission is that, Your Honor, if the. No, on the other day, both of you have consented to withdraw this application.
yes,
Hmm?
with a liberty.
With
That
a
was
liberty.
yes,
And this matter was disposed of.
yes.
Now, can we again, on the basis of this interlocutory application, revive the case which has already been disposed of?
This of yes. That is, my lord, what happened under section 115 of the CPC, my lord.
No, that is there. Power is there,
Yes, my
but
lord.
that power is not unfettered.
But my lord, what happened? May I pray, my lord? One order just 2 days back, your lordship passed one order in CRP IO number 9123. In that case, your lordship dismissed the petition CRP IO because they came. Their petition was filed before the trial court under Order 9 Rule 30. Because that order is different, my lord. Because there was a decree. But in our case, there is no decree. Therefore, we cannot, my lord, file any application because that was initial stage in our suit, my lord. In our suit, it was initial stage just because of the wrong, my lord, address of the defendant number 1. Their brother and sister, my lord. The same address was given by the plaintiff. Plaintiff has given the same his address as the address of the defendant number 1. And defendant number 2 is also there. He is also one brother, my lord. Therefore, this dispute is, my lord, it's a very small dispute regarding the suit is specific performance of contract, my lord. Therefore, if your lordship allow the, my lord, this IA, my lord, interlocutory application to restore the CRP IO, and thereafter, my lord, if your lordship allow this petition CRP IO 226, which is filed CRP IO number 16 of 2025, which was filed to, my lord, against the order for not allowing the, my lord, ex parte order, then, my lord, this defendant number 1 can file the written statement. And we are ready, my lord, if your lordship allow, within 1 month we will file. Because this, my lord, suit is in between only brother and sister and regarding only specific performance of contract. It's not between any other party, my lord. And this suit is still going on, my lord. Now, this honorable court, lordship, may 2006 3 SCC 699, Jet Plywood Limited, here, my lord, small paragraph. May I read, lordship?
Yes.
Paragraph number 25. 24 and 25, my lord. From the order of the learned civil judge, senior division 9th court, Alipur, it is clear that he had no intention of granting any leave for filing of a fresh suit on the same cause of action while allowing the plaintiff to withdraw the suit. That does not, however, mean that by passing such an order, the learned court divested itself of its inherent power to recall its said order, which fact is also evident from the order itself, which indicates that the said court did not find any scope to exercise its inherent power under section 151 of the Code of Civil Procedure for recalling the order passed by its earlier in the circumstance set aside the order dated 24/9/2024. The learned trial court felt that no case had been made out to recall the said order, which had been made.
Mr. Goswami, you see, here you are the person who had prayed for
Yes,
Asking
yes,
you
Lord.
to withdraw the suit or withdraw the petition.
Petition.
And taking note of your submission, this matter was allowed.
With a liberty to file the language of your lordship's order.
Why don't you file a fresh one?
My lord,
While liberty was granted to you.
yes, yes. Because liberty will remain with the petitioner to approach the appropriate forum, my lord, by filing appropriate petition. Now there is no forum in the CPC, my lord, to file appropriate petition except this, my lord, except to restore this CRPIO, my lord.
You can file a fresh one.
Because there will be a very long time delay, my lord.
Maybe.
And the suit will be delayed, my lord.
Maybe. Appropriate forum means including this court.
My humble submission, my lord, as because your lordship has not stated that trial court or any other court, appellate court, appropriate forum, if my humble submission is this is also, this honorable court, high court is also an appropriate forum, my lord.
And then?
Because for speedy trial, my lord, in
No,
fact,
no.
I withdraw like for speedy disposal of the case.
No,
In
no.
fact, I could have
For speedy, in the name of speedy trial, this court cannot restore one case which has already been disposed of on the pair made by you.
yes, my lord. But this honorable Supreme Court has given this liberty to your lordship to restore. Section, this para 25 of that order, my lord, because under section 151, your lordship has the power to restore it.
We'll see. You furnish the case number to the court master. We'll list it on some other day. We'll see whether we can do it or not.
Lordship.
Heard, Mr. Gusaf,
Heard,
learned
sir.
counsel for the applicant, and Mr.
And Pandit.
Learned counsel for the respondent. List the matter in the next week for further consideration. You give the citation to the court master.
Yes.
Your Lordship. I'm appearing on behalf of Mr. M. Sekia. As per the office note, it's written, neither AD card nor unserved notice have returned for the respondent till date. Therefore, your Lordship may kindly allow the petitioner to take.
Heard, miss, your name, please.
I'm appearing on behalf of Mr. M. Sekia.
Learned counsel appearing on behalf of Mr. M. Soikia.
Yes.
Learned conducting counsel for the petitioner. Office note dated 9/2/2026 indicates that neither AD card nor unserved notice issued to the respondent returned till date. List the matter after 2 weeks, awaiting service report upon the
Lordship,
respondent.
25, if the matter can be taken, 25
25.
February.
Let's just list the matter on 25th of February. Awaiting service report upon the respondent.
46.
Yes.
May I please, your lordship. Lordship, the petitioner is the tenant of the respondent.
No, you say the matter is listed under the column order. Whether service completed here?
Yes, only sole respondent.
Completed.
Lordship, it was fixed day before yesterday and last Friday. And since execution is going on, your lordship has fixed it today.
Yes, what is your instruction in respect of the interim pair?
Actually, in respect of the title execution, that is fixed on 19 to of February.
Hmm.
We have submitted the cost for the police aid, Lordship, but
Hmm.
no order has been passed since they have already filed a petition and the order of passed by the Honorable Court on last occasion, Lordship. Therefore, no order was passed and switched for necessary order.
No, that doesn't mean that we will not pass any interim order here.
Lordship.
Hmm? So then we will finally hear the matter.
Lordship.
Lordship.
Very nice. Wait. Service. Heard Mr. Khandelia,
Lordship.
learned counsel for the petitioner, and Mr. Bora for the respondent. Mr. Bora, learned counsel for the respondent on instruction submits that no adverse order was passed by the learned executing court. Executing court. In that view of the matter, registrar lists the matter on 26th of February, on which an endeavor will be made to finally hear and dispose of this petition.
Lordship, the date is fixed on 19th of February for the executing court. Till then, nothing, no execution. Only that.
If they again place this order, what your Lordship has just passed.
Will not take any adjournment. We can undertake before this court, honorable court, that will not take any adjournment as per any date. At least till then, some protection. Only that much. I am a 30-year-old, 30 since last 30 years. I am a teenager. I am 65 years old, Lordship. Some protection till the date of hearing. Only that much.
Because if your Lordship.
Otherwise,
No. If the learned trial court, executing court pass any adverse order against you, you mention the matter
Lordship.
before this court.
Lordship, both will jointly file petition. That date is fixed. That will suffice, Lordship. If my learned friend agree, we'll jointly file that the matter is fixed for hearing. Till that, no order. Only that much. On the next date, before the learned court.
No, we will not pass any order today here. You may file joint application there, no bar.
Because if they will insist for to pursue the execution.
If they insist, then you mention this matter.
Lordship.
We will hear you
Lordship,
then.
yes.
Wait, this is your Lordship. Lordship, this is a delay petition, but delay is of only 5 days. Can Lordship condone the delay? This is listed for the first time. Other courts, Lordship, for small delays, it is condoned.
Let notice go ahead, this is this.
Notice. Okay, Lordship. Otherwise, since only 5 days, Lordship, I was praying that Lordship will condone the delay.
5 days.
Only 5 days. The council provided the
No,
judgment.
the problem is that after receiving notice, the other side will appear. Then they will object that order was passed
No,
without
Lordship,
hearing.
other courts, Lordship, if I may mention the judges also, PJ Soikia, then Madam also, Fukan Madam also.
No, it depends upon court to court.
Yes, Lordship. Because this will be totally unnecessary and in service itself, High Court case itself, not on.
No, what to do if the parties
Yes.
does not take any step properly?
Yes, that is true.
Let notice go at this is this.
Okay, Lordship.
Miss R.D. Mazumdar, learned counsel for the applicant. This interlocutory application under section 5 of the Limitation Act is preferred by the applicant appellant for condonation of delay of 5 days and preferring connected appeal against the judgment and order dated 25/11/2025 passed by the learned Employees Compensation Commissioner Kasar Silsor in EC case number 4 of 2017. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by registered post, speed post with AD and also by usual process within a week from today. Place the matter after 4 weeks. So what happened earlier? We have passed one order.
That day we had taken time, Lordship, 2 days back.
No. In another matter.
Okay.
Thereafter, one counsel entered appearance that ex parte order was passed by this court.
For that small delay.
Yes.
Okay. It is counsel to counsel.